Hey, good morning, good afternoon, good evening, everybody. How are we doing? It is time. It's time for a new trial. I've been keeping this one a little bit close to the vest. Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land, I'm a Moorish empire or whatever, bitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and just get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. God dang, you're right. Moorish empire. Traveler on the land. Bitch snitch. Moorish empire. God dang, you're right. Traveler on the land. Bitch snitch. The late evening U.S. people. Hey, good morning, good afternoon, good evening, good night, everybody, whoever you are, wherever you are, whatever you're doing. I'm just glad you're doing it here with me, Legal Vices, because this is my channel. Legal Vices, this is where you find me, and you found me because you're here. We got 120 people right out of the gate, and we're growing every second. And please, when you come in, just make sure you hit the like and subscribe, do all that stuff. We'll talk about it real quick here. We got a lot to cover today, so we'll keep the background noise, all the housekeeping stuff to an absolute minimum today, because we got to hit the ground running. What we're doing today is we are doing the Jennifer Crumbley closing arguments. The case is over. She's been found guilty of 4 counts of involuntary manslaughter. I do not know much about this case. I've seen a few hours of it total, being on other people's streams and doing it. But so I don't know a lot about it. But a lot of you were saying the closing arguments were really weird, and I need to react to them. So normally I don't do this unless I'm familiar with the case and I can make intelligent comments about it. So what you're going to do is you're going to get some raw comments based on basically what I know about this case is mom and dad are both on trial. They're being tried separately. I guess he was 14 years old at the time, son. They taught him how to shoot. They bought him some guns. He exhibited what may be some signs of mental illness and cries for help. He eventually goes and shoots up people and killed 4 people to school, and they charged. Well, he pled guilty and got life without parole, I believe. And now they're they brought their charges against mom for involuntary manslaughter. So they're charging her with involuntary manslaughter because her son killed some people. Right off the bat, I don't like it. I don't like it. To be convicted of involuntary manslaughter for something that somebody else did, there's a very high evidentiary threshold you have to. Of course, it's a guilt beyond a reasonable doubt, but you have to meet the elements of the crime. And I assume that the prosecutor is going to be very, very helpful and tell us at the beginning what the elements of the crime are. So what I hope to be able to do as we go through this, as we go through the closing arguments, just to kind of see how the closing arguments progress and to see whether each side seems to have whether the prosecution seems to have met their burden of proof on each of the elements of the crime, and whether the defense seems to have rebutted any assumptions that were, or anything that was proven, I guess, by the prosecution. And from what I have seen, both the prosecution and the defense lawyers are a little bit odd. And the judge seems to be a little bit odd as well. So maybe that's why you're all saying to watch these closing arguments and to react to them. Because like I said, everybody involved in this has seemed really, really odd to me. I know there was, even though they would make objections, they would just sit there and argue back and forth. There was no sidebars. They would just argue back and forth until the judge had enough, apparently. So, all right, we're gonna figure out what this is all about, and see, and we're just gonna react. We're gonna react cold to it. And let's see, before we get into this, let's say some highs. Hello to everybody here, the 172 of you here. It's time to get going. We have our like and subscribe poll. So we got 172 and 104 likes. That means like, well, now we're up to 180. So 76 of you haven't done your job. 76 of you get down there, hit that like and subscribe button. Those of you that are subscribed, thank you so much. We got just chewed. YouTube sent me into a time of trial again, because you get a few, then they knock a chunk off. They knocked about 100 subscribers off in one day. But everybody from that was here yesterday for the David Neal, the Tonsil twins, Clayton Eckert case, you guys made up for it. We got a bunch of subscribers out of yesterday. Cut that deficit right back to right up to about where YouTube started. I deeply appreciate it. If you're here for this, strap in, because this is supposed to be kind of wild. Let's find out. Make sure you're still subscribed if you think you've subscribed. I appreciate your subscriptions. And then come over here and take our like and subscribe poll. This is a very, very basic poll today, because I want to hear what you have to say as we go through this. Do you agree with the verdict? That's the question. 30 of you have voted that haven't hit the like button. So you 30, repent and get down there and hit that like button. So far, 24% of you say yes, and 76 of you say no. 76% of you say no. So it's a 3-to-1 margin, but there's still a good chunk of you that think that the verdict was a fair, just, and based verdict based on the evidence presented by the prosecution. So I'll be interested to watch this closely and see. What we're going to do is, because there's about 3 hours, we're going to be watching it at 1.25 speed, and I'm going to try not to stop the video unless it is absolutely necessary, which, if you know anything about me, is probably going to be about every 25 seconds, but I'll try to resist. And we've got people here. Hector Salamanca is here. Paralegal Liz, what's up? Paralegal Liz, Joe Choi's box, and who was the other person? They reached out to me by email, and my mind, Jennifer, I believe it was, your box, the box that has both of your stuff in, has just cleared customs. So, and Friday through Monday is a Lunar New Year holiday here. So if it comes tomorrow, we'll do an unboxing tomorrow. If not, it'll come next Tuesday. So we'll do the unboxing then. Tomorrow we do have the O.J. Simpson trial. O.J. Simpson closing arguments. Barry Scheck, Chandler Remington, and I will be presenting that to you as we do every week as we wind down the O.J. Simpson trial and begin a new trial in a few weeks. And Friday is going to be sort of a chill stream, kind of a catch up on some outstanding cases. Where Are We with Courtney Clenny, Sarah Boone, Karen Reed, Hannah Gutierrez Reed, the Rust shooting. We're gonna kind of do a little bit of update and see where we are with all of those. So that'll be Friday. Everybody, welcome here. Silent PS. I can't name everybody by name, and I don't want anybody to feel left out. But Aussie Overlord's here. Good to see you, Aussie. What's up? Don't teach your kids to drive and get them a car. You'll be found guilty of vehicular homicide. Oh, and be liable for the parking tickets. Oh, dear. I certainly hope that's not an example that's used in the. All right, let's jump into this. Nicholas is here as well. I just see a hi, Nicholas. So I'm assuming I didn't see Nicholas's message. So we'll assume that Nicholas Starro is here. He's lurking, always lurking, unless someone's just shouting and trying to mess with him. So, all right, good morning, good afternoon, good evening, good night, everybody. Let's get into this closing Closing argument breakdown. Woo. All right. Hey, Flux, what's up? The Sock Snatcher. I like that nickname, the Sock Snatcher. The defense attorney, in my opinion, was shit. From what I've seen, they were both kind of shit. But let's find out. Enough of my talking. We have Doggo Cam locked and loaded and ready to go here. Both dogs are present in the room. For those of you that don't know, we unlocked Doggo Cam achievement at $100 worth of super chats. Anybody gives $100 super chat, that requires me to take a shot of whatever beverage I have sitting here next to me. Super chats are not required, not even asked for, but they are graciously and gratefully received. And whatever you super chat is guaranteed to be read and addressed. Otherwise, I try to see what I can pick out of chat as I focus on this and give my comments. But the super chats are the absolute most guaranteed way that I'll see your message and I read it. Been there, done this. Says, hi, Jeff. I'm here. Hi. So, okay, that's it. The super chats, as they come in, we'll read them as usual. So let's start the ball rolling to Doggo Cam, and let's start the oldie trial. I need to get a new cuck cage for the embiggened new Law and Crime logo. That's where we sit. All right, folks. Make sure we're at 1.25 speed, which we are not. We are at normal speed. All right, now we're at 1.25 speed. And if it seems like it's too fast, give it a couple of minutes to adjust. And if it's still, after a few minutes, you think it's too fast, then I acknowledge you, Island. I see it. If you still think it's too fast after a few minutes, then we'll slow it down. William, my dogs are doggos. If you see them, you know. Member for 13 months, KT, kicking us off with a monthly membership. Just shout outs here. I gave the like button a blowy, and now I'm carrying triplets. All right, well, see, I don't believe that. Twins, possibly. Triplets, yeah. Sorry, I'm gonna call your bluff. John Gary, our resident devil's advocate, our resident contrarian, says, in my opinion, state closing was good considering the case you had to work with. Defense close was bizarre and I hated it. Though some loved it, state rebuttal was very lackluster. All right, let's find out, shall we? All right, without further ado, let's go.
Okay, thank you.
Just for podium.
Good afternoon.
Nick! Have you seen the vet?
Told you in jury selection,
Yeah, I saw her interview.
And it's now been 2 weeks, so we're a little bit ahead of schedule.
She's crazy.
Thank
you so much, Nicholas. Thank you so much for your support.
And
good to see you here, brother.
Going through the evidence, and I'm going to spend some time going through the elements of the crime. I want you to know that.
Oh, good. See,
I've been watching you.
As any good prosecution closing should start with the elements of the crime.
What I'm not going to do is spend a lot of time repeating everything that was said from the witness stand because I know that you all listened, and I also want you.
I have a sneaky suspicion that's exactly what she's going to do.
I told you during jury selection that it wasn't going to be easy, and it was not easy. Listening and watching.
I've just poured myself a lovely old fashioned with 3 Luxardo
being gunned down
cherries on top.
Is not easy. You listen to every witness. You examine the evidence.
The elements.
And I suspect that many of you feel the way that we do, that it's difficult. But we owe it to the victims and their families to say what really happened. And you've listened and you've done that. In our system of justice, we have different roles to play, and each role is different. There are people who think it's the prosecutor's job to. All right, people.
I will boost the court volume.
I don't think that's the prosecutor's job. I think my job and our job is to present the evidence and the facts and tell you the truth.
Oh.
And telling the truth sometimes means showing you things none of us want to see. Some of us don't agree with. Some of us don't like.
Let's see if we actually get a prosecutor to tell the truth.
We don't pick or choose the very best things because I believe that you should have the truth. And I believe that it's not my job, nor is it right to sanitize what happened in that school that day. Because if we don't tell you exactly what happened, then you don't know all the facts and you don't know what the
Diane Tessier has been a member for 2 months, says Shannon's closing was a joke so crazy it was more about her than her client. Absolutely insane. I'm assuming from context that Shannon is the defense lawyer.
We have done.
So we'll see.
Burden to prove that Jennifer Crumbley is guilty of 4 counts of involuntary manslaughter.
All right, let's see why.
Is high. I told you that during jury selection, but we embrace it. And I believe that we have met that burden. It means that you had to sit and listen to a lot of very emotional things a lot of emotional people who sometimes aren't emotional, but we're emotional for this because what happened on that day, every single person in that building had never experienced anything like that in their entire lives. And I hope to God they never do again. So you did see a lot of people, including law enforcement, become overwhelmed with the emotion of it all. That's not a show. That's just how that was. That's how it felt that day and every day after. So I want you to know that there was no picking and choosing the very best evidence to give you. There was no filtering things out that didn't help our case. I showed you everything.
That's kind of a weird thing to
And I
say.
called
You
witnesses
do want to
and
pick and
to
choose
say
your
things
best evidence.
I knew you probably wouldn't like. But my job is to give you all the facts. But my job is also to prove beyond a reasonable doubt that Jennifer Crumbley is guilty. And I believe we've done that.
All right.
The defense also has an important job to advocate and argue for their client. And they decide how they want to do that. And of course, the judge plays an important role. Her job is to call balls and strikes when two sides disagree, to make a ruling and then to tell you what the law is. And she's going to do that as soon as we conclude here. And then there's your job. Your job is to decide what the truth is, what really happened, what are the facts, and then take those facts and find the truth and apply the law. The judge is going to give you instructions about the law, but I want you to go over what you now know, and I want you to think about it. And we're going to go over some of the evidence. But I also want to remind you that you're allowed to use your own observations and your own insight. And if there's something that you notice from the witness stand that I didn't say, you should rely on that. We can't possibly tell you every single little thing. And sometimes, ladies and gentlemen, the most important things are the things that don't get said.
What?
The most important things are the way the victim or the witness spoke, the way they answered a question. And I encourage you to rely on your own perceptions of that.
Okay.
I want to start out by talking to you about the elements of the crime.
Well, good. That would be helpful. What are the elements of the crime?
Involuntary manslaughter. She is charged with. This case is based on two theories. You're going to have all this in their jury room, but hopefully I'm going to explain it so well you will have no questions. These are dependent on two specific theories. One is the gross negligence in the performance of a lawful act, and that gross negligence caused death, and in doing so, the act that caused death, the defendant acted in a grossly negligent manner. The second is the gross negligence in failing to perform a legal duty. One, I have to prove that she had a legal duty to the victims. Two, she knew of the facts that gave rise to the duty. Three, she willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. And then four, the death of the victims was directly caused by the defendant's failure to perform this duty.
Okay, wait a minute. I got to write. I want to write those down here. Hang on. I want to write those down as a reference so that we have have something to look at and see if she argues each element of the crime. Defendant had a legal duty to the victim. Had a duty to the victim. Okay. 2, knew the facts that gave rise to the duty. All right. Knew the facts that gave rise to the legal duty. And 3, willfully neglected. Willfully neglected or refused to perform that duty. And that failure was grossly negligent to human life. Grossly negligent is an interesting term there, because grossly negligent is beyond normal negligence, and it's almost to the point of an intentional act. And that failure was grossly negligent to human life. And 4, the death occurred as a result of the evidence, as the result of the negligence. The death occurred as a result of the negligence. And on the performance side, performance of a legal act, very simple, caused the death. 1, caused the death. 2, the act was committed in a grossly negligent manner. Okay. There, I think we're locked and loaded and ready to go.
And then 4, the death of the victims was directly caused by defendant's failure to perform this duty. Causation.
Okay.
The judge is going to instruct you, maybe more than once, and I'm going to say it, that there may be more than one cause of death. And it's not enough that the defendant's acts made it possible for the death to occur. In order to find the deaths of Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's actions.
Natural result of the
The
actions.
defendant's son shot Madison Baldwin, Tate Muir, Hannah, and Justin. And as previously noted, there may be more than one cause of death. And defendant's acts or inactions need not be the sole cause of the harm. In order to find that the death of Madison, Tate, Hannah, and Justin was caused by the defendant, you must also find beyond a reasonable doubt that her son's act of shooting these 4 individuals was reasonably foreseeable. Now, you
See,
look
that's
at
where I have the problem.
all of that I have to prove. And it
Okay.
seems a lot. It seems like it's going to take a pretty strong case to prove that.
Yeah, it does.
Some pretty egregious facts. Some unique, egregious.
Yeah, because you have to show there's some that she owed some duty to the victims, and that her not performing these duties
More than just careless. It means willful
somehow. I don't know. I'm waiting for her to tie this into the kid. How the kid's actions are imputed to her.
The following 3 things. 1, that she knew of the danger to another. She knew there was a situation that required her to take ordinary care to avoid injuring others. And second, that she could have avoided injuring another by using ordinary care. Third.
Okay, see, this is the thing. I have no idea how they're going to tie this action into her, because it means willfully disregarding the results to others that might follow from an act or failure. In order to find that the defendant was grossly negligent, you must find each of the following 3 things. The defendant knew of the danger to another. That is, she knew there was a situation that required her to take care to avoid injuring another. It's actually, to me, you're actually saying that she had to know that her son was going to commit an act that would injure another. So it's kind of one additional step in here, and that's where I'm waiting to see how this all ties in.
Use ordinary care to prevent injury, and to a reasonable person, it would have been apparent that the result was likely.
So she had to take action to stop her son from taking action that would naturally result in the harm to others.
They're both based on a legal duty. What's a legal duty? In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child, to prevent that child from intentionally harming others, or prevent that child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others.
Okay, child. Define child
We
for
talked about
me.
there's 2 alternate theories.
So you have a
Either
duty
both of those
to
theories
prevent your child from harming
to
others.
establish the crime of involuntary manslaughter. It's not necessary that you all agree on which theory has been proven. And as long as you all agree that we've proved at least one of those theories beyond a reasonable doubt, you can find her guilty. I want to take you through the testimony.
All right, again, sorry to keep pausing this, but now they're going with both theories of guilt. Okay, that's kind of weird to me. That seems a little bit strange. Normally, I would think you would pick or choose one of the theories. Either she's guilty of the gross negligent in performing an act that resulted in this, or she's guilty for not performing an act that she had a duty to perform. They're saying you can find she either had a duty and didn't do it, or she didn't have a duty, but this is kind of strange. I think it's kind of strange. So either find her guilty because she was negligent in performing a legal act, or she was negligent in not performing a legal act. All right. Now, Porcelain Thunder, I'm going to highlight this comment here. She provided the means and methods for her known disturbed kid without taking adequate precautions. That goes back to what Ozzy Overlord mentioned a minute ago. So does this mean he can't drive a car? Does this mean he can't, ride a bicycle? Does this mean he can't go shopping alone? Does this mean he can't go? This is a kind of an interesting slippery slope. I want to see how this gets addressed later.
I'm not going to get into every single detail of each of these witnesses' testimony because I know that you were listening and you were writing.
And Nicholas Starro, Trial Watch, again, thank you so much for the support. Sir, should I buy currywurst flavored potato chips?
She was in room 2.
Well, I think you should buy 2 bags and send one to me because I'm curious. Thank you.
Shoulder height pointed directly at her. And what she noticed was there was no orange tip. You also heard her say that she locked eyes with Jennifer Crumbley's son as he was taking that stance.
Okay.
You heard her testify that she jumped to the right, thank God, just in time, because the shot in her shoulder that she sustained was only inches from her heart. The next witness you heard from was Christy Gibson Marshall, who's an assistant principal at Oxford High School. I don't think there's one of us that would disagree that Christy Gibson Marshall did the most dangerous thing she could do. And she did not follow the protocol. It's probably one of the most courageous things I've ever seen. She walked to the shooter. She saw a student on the floor.
Okay, so what does this have to do with mom?
Being face to face with the person who had shot this student. She didn't move.
Hey, Megan Fox in the chat.
And he didn't shoot her.
Okay, so again, I'm waiting. What does this have to do with mom?
Middle school, and she just couldn't believe that he would do something like that because she knew him when he was in middle school. You saw the video of that day and what happened, and he just kept going. And even after he left, and she had no idea where he was going, she didn't go hide anywhere. She didn't keep herself safe. She bent down to render aid and assistance to that student. And when she rolled him over, she realized it was Taymir. We all know that she didn't and wasn't able to save Taymir. We heard from Tammy Gatt, who sold the Caltech and the Derringer to James in June of 2021.
Oh, no, okay.
6 hours to
Wait.
James with the shooter present.
All right, so now we're even one step further. They can't say the mom bought the gun. Can't say mom bought the gun. James is the husband, I'm assuming, because he's the only other adult. So the father was the purchaser of the gun. We're still not connected to mom.
Day after Thanksgiving. She testified that James came in and pointed right at the SIG and said he's had his eye on it. She walked us through the process of purchasing a firearm. She talked about the trigger lock statement provided to James upon purchase and the cable lock provided with November 2021 on that gun purchase. Next week,
Okay.
Special Agent Brett Brandon, who's sitting right here. You heard that when he was informed about the Oxford shooting, he left so quickly that when his partner came back, his chair was still spinning.
So
He raced and drove up there as fast as he possibly could because it was very much his own community. You heard he went right in and he found Lieutenant Willis and he said, "Do you know where the gun is? And do you know where it came from? And do you need help?" And so he was responsible for finding out where that gun came from, which he did. He was also responsible.
that's not hard. You check the serial number and see who was registered to the end.
The video and helped to prepare search warrants. And you heard him testify that as soon as he saw that surveillance video, the one thing that stuck with him is this is not an inexperienced shooter. This is a shooter that knows that is proficient with a firearm, knows what he's doing. Taking shots, a lot of people wouldn't. And what he did was start going to gun ranges and ask people to say, because what he was thinking was, who taught that kid to shoot? He must have been to a range, and he was right.
Okay. See, this is where I'm curious. Guys here in chat, I want to hear your thoughts on this because I'm wondering how much of a generational as well as cultural difference there is here. He was 14 years old when this happened. When I grew up, where I grew up, in the top of the Rocky Mountains in Cowtown, northern Utah, if you were 15 years old, especially a 15-year-old boy, if you were a 15-year-old boy, 14, 15-year-old boy, and you didn't already have a gun or two, there was something wrong with you. People are like, what do you mean you don't have a gun? Come on. And middle school, they offered hunter safety courses all the time. I think they would start like one class a month. I took hunter safety, I believe, I want to say 10 or 11, maybe even as early as 8. Somewhere, I mean, be preteen, I already had my hunter safety certification and things. Everybody did that. And I mean, I had my first BB gun, I think, when I was 5 or 6. I got my first shotgun to go hunting with my dad at 12. I had a 22 at some point before that. I think I got the hand-me-down 22 after finishing the hunter safety course. And I know I've mentioned it several times before. Everybody, okay, everybody is an exaggeration, but a huge number of people. We all had trucks or cars, but in the back of the trucks, you would have a gun rack. And there were people with guns, loaded guns in their gun racks in the high school parking lot. That was just normal. That's what it was in the 70s and 80s in rural Utah. And so, I mean, but now there might be younger families that even families that live out in farm towns. There was no way I would never, ever allow my child, no matter how old he was, I would never purchase a gun for them. So I'm wondering how much of a generational and cultural gap there is with people here that are watching now. I'm fascinated by that, because I'm thinking it's weird that the kid is 14 years old and he's just now getting his gun. And to me, they're making it sound sinister that they bought their son a gun and trained him how to use it. It would make a lot more sense if they just said, Merry Christmas, son, here's a gun, and didn't properly train him how to shoot, didn't properly train him. It's not like they were going down to the local assassin's course and teaching him how to be an assassin. They bought him a gun and responsibly taught him how to use it. It sounds like what she's saying to me. So, and this is just something I'm keeping in my head as we go through this. I find it fascinating. Little dog Chaz, member for 11 months as legal advice, I was shooting competition at 8 and won a world championship at 11. Sweet. That's cool. Yeah, so, I mean, it's just something that guns were such a natural part of my life growing up. But I guess it's different times, different world. But to me, it's very, very strange that the prosecutor is trying to make it sound sinister that they got a child who's nearly an adult. He's just a few years away from being an adult, a weapon and taught him how to use it, apparently properly from what she's saying. And she's making it sound like they were training an assassin.
And that's how the investigation led to where.
Yeah, it would make more sense, Megan, if they didn't train him.
How to handle a firearm that eventually resulted in killing 4 students in Oxford High School. Can you go back to that? Special Agent Brandon also testified that and showed the purchase and we showed you each one of those guns.
Diane Tessier said Shannon's closing was a joke. So crazy it was more about her than the client.
The 9mm.
And again, I read this a little bit earlier.
From him was that 9mm is
I'm curious about this too.
Gun.
What?
It causes more damage to whatever it hits. The bullets are a large.
Wait. Then what? I'm sorry, I was talking over myself.
The 9mm.
Okay,
and what he really heard from him was that that 9mm is a much more dangerous gun. It causes more damage to whatever it hits. The bullets are a larger caliber.
Not necessarily more dangerous. Sorry.
Very dangerous weapon.
All guns are dangerous. All guns are very dangerous.
With every gun purchase, which is the ATF pamphlet. He read to you about the warnings. There's a reason they put it in every single gun purchase. And its sole purpose is to protect kids from gun violence deaths. He talked to you about what a trigger lock is and the trigger lock statement. He showed you the Instagram post that's unforgettable. We don't have to really argue about whose gun that was.
Kind of do, though.
Jennifer Crumbley told us whose gun that was. She told us when she posted on social media, it was his Christmas present, and she told you in this trial. That weapon
it was a
is
Christmas
not just that weapon. It is the defendant's son's gun. It was gifted to him. And not
by the defendant, apparently.
She bragged about it on social media before the shooting. Special Agent Brandon also introduced all of the surveillance and the videos of the shooting range. And you got to see with your very own eyes the training and the preparation that the shooter ultimately used to kill 4 of his classmates.
Okay, I don't like the use of the word preparation there. Training, yes. Okay, you can see on the video that he was trained how to use the weapon, but how he was in preparation for what he was going to do, that seems a little bit loaded. Future Mrs. Martin 2.0, hey, how you doing? Thank you so much for the $10. Gratefully accepted. Oh, cute little doggos there. The argument I keep hearing from people is that they bought him a gun knowing he was struggling with mental health issues. Therefore, mental health struggles equals mass shooter. Wow, let's see how far down that path she goes. I'm guessing you're probably right about that. Mm-hmm. So let's see how that goes, because that is also a slippery slope. And all right, let's go. Thank you so much for that. There are more things to think about as we move forward. Thank you, future Mrs. Martin 2.0.
We all saw that. We actually saw the last day he was practicing to kill 4 of his classmates. And there was only one person with him, ladies and gentlemen, and her name is Jennifer Crumbley. And I want you to remember that video.
What about the
look on his face when that target comes back in and he looks at it and he's smiling.
Well, maybe he was proud of his group.
And also introduced the worksheet. You've seen the worksheet a lot. I bet you that worksheet's burned in your memory, and I wouldn't even have to show it to you. But what Special Agent Brandon testified to and showed you is that wasn't just a picture of any gun. It was a picture of his gun, which was the murder weapon, and he showed you the details, and we're going to talk about that later. And next, we heard from Ed Woodrowski. We now just call him Ed because he works for the Secret Service. And he testified for an entire day, and he had a lot of information, but he also really couldn't help himself from becoming emotional. And I know that you're going to remember this, but what an extraordinary thing that's just not seen very often. He sat right there and he took you through every single action of the shooter and every single death from his memory. And he told you that he could do that because it's burned in his brain.
Mm-hmm.
These are seasoned.
Patient Tangent 2401. Thank you so much for the super chat. The gun safety used to be taught in public schools. Yeah, I just mentioned that I received my hunter safety training course in middle school, like at the middle school.
It's my closing.
What a witness.
Oh, what the fuck? Wait, what? Time out.
They hate showing emotion. He probably will never forgive me. Lieutenant Willis tells me all the time how much he really hates me.
Wait, what?
It's my opening. It's my closing.
What a witness tells her all the time. That's not evidence.
I'll move on.
Oh, please tell me it's not going to be like this the entire, because the little bit of this trial I saw, was like this, where somebody would make an objection, the other one would look all put upon, and then they would argue back and forth, and finally the judge would go, all right, whatever, and rule one way or the other. That was weird. As soon as there's an objection, the prosecution should have stopped talking, should have waited for the judge to say, what's your objection, and then made a ruling. And oh my God, I'm in the middle of my closing arguments, God. And meanwhile, she's talking over her, she has a point. What this guy tells you all the time is not evidence and has nothing to do with it and shouldn't be in the closing arguments, as far as I'm concerned. But, oh, damn.
Nobody likes doing that. Nobody likes doing that. But it tells you something about what it was like that day.
Oh, great.
And despite what anybody will tell you, it is about the shooting. There are 4 counts of involuntary manslaughter. It's very much about the shooting because the shooter learned how to shoot and was given the murder weapon by his parents. And this parent is sitting here today on trial.
Oh God, I'm sorry. This is I said I wasn't going to stop this often, but I have to, because no, he gave her son the murder weapon. She gave her son the murder weapon. What does gave it mean? Like, here, son, here's a weapon for you to do whatever you want with it. Or was it the gift and she controlled how he used it? And when he had access to it and how he had access to it. And even if she did control that, did he do something that he wasn't supposed to do to gain access to the weapon? Just to say they gave him the murder weapon as a Christmas gift. Yeah. As I said, my father gave me, including my BB gun, 3 guns by the time I was 12. Yes, he gave them to me as a present, but he also let me know that if I ever touched him when he wasn't around, he'd beat my ass and I would never see them again.
Okay. You'll be able to review the evidence. It was a lot. But he talked to you about what cell phone extractions are. And because of the cell phone extractions, we have a mountain of evidence that you saw. And yes, it's a lot of data. But you know what else it is? It's telling you exactly where the defendant was, who she was talking to, what she did, what she didn't do. And you can't hide from that. She tried. There's a lot of deleted messages, which are not coincidental.
Okay, that's
I don't think-
interesting.
I don't think any of you believe that, but I'm going to tell you why they're not coincidental. He also talked to us about and showed you the messages between Jennifer Crumbley and her son. The messages between her son and his only friend. He introduced the voicemail that Jennifer Crumbley received the night before the shooting about looking up bullets. True. Pam Fine didn't tell her to call back. That's true. And she didn't call back because she didn't ask for a call back. We all know what she did do with that information. What she did do with that information is she texted her son, searching bullets. And we all know the phrases that we'll never forget. Did you show him your gun? This is the day before the shooting. Did you show him your gun? And the shooter responds, no, my God. LOL, I'm not mad. You just have to learn not to get caught.
Okay, that's some weird text messages, but okay.
Kira Kennett testified that she knew Jennifer Crumbley. She testified about the amount of time that Jennifer Crumbley and James Crumbley spent at the barn. She testified about all the money they spent at the barn. Why is this important, ladies and gentlemen?
Oh yeah, I think so.
It's not
Oh,
to show you that
absolutely.
somebody's a bad person for liking horses or spending a lot of money on horses. It isn't. And it's not to say that somebody should spend every waking hour that they're not at work at home with their teenager. That's not the purpose of this evidence. The purpose of this evidence is to show you what Jennifer Crumbley cared about the most and what she was doing and where she was when her son learned to be a killer.
Son learned to be a killer. He went to killer school?
That she referred to her son as an oopsie baby and said he was weird. She rarely saw him. And that even after the one friend was taken away abruptly with no notice, they still went to the barn even at night and left him by himself. Which is
What does how much she spend on horses have to do with anything?
Unless that teenager is showing signs of mental crisis and that teenager has lost the only person in the world that he has. And then she told us that when she got the worksheet texted to her that day by Jennifer Crumbley, she was very concerned. She was alarmed. And in fact, she said, bring him to the barn. And you also heard saw from the text messages that Jennifer Crumbley said, he can't be alone.
Okay.
We know now that decision, that statement, she knew he couldn't be alone. She didn't decide to stay home with her son. That wasn't an option. She'd have to take him to the barn, where she herself testified he didn't want to go.
Well, I went a lot of places I didn't want to go when I was 14 with my mother.
People who were at that meeting that day. Sean Hawkins and Nick Ejab. I'm going to tell you right now that this is not an argument that the school did everything they should have done. I'm not going to say that to you. I'm not going to tell you that I like everything they testified to. I'm not going to tell you that I think it was okay they didn't look in the backpack. I don't think it was. But this is about Jennifer Crumbley's actions. And any attempt to make it about
That's a
what
point.
these two individuals did or didn't do, like it or not, who did not have any of the information that was so jarring. It's about what she knew and what she didn't say.
All right. Again, maybe this is a generational thing. Maybe we don't do this anymore with counselors and things at school. But when I was a kid, my school counselors probably knew more about what I was up to than my own parents did.
Sean Hopkins testified that he was concerned enough that he called Jennifer Crumbley. And her
Okay.
first response is, can you call his dad? Eventually, he emails her both copies of the worksheet, the original worksheet and the worksheet that was scribbled on. And she eventually comes to the school. But before she comes to the school, she texts her husband, emergency. Emergency. Along with, I'm very concerned. And James texts back, WTF. They're concerned. For the first time she testified ever, they're calling
Well,
the
of
school
course.
in the middle of the day.
The school calls you and says we
Hours.
need to talk. That's exactly what would
Sean
happen.
Hopkins is
My
gonna
mom
tell
would
you
call my dad and go, all right, we
calling
got a problem
parents in
here.
the middle of the day and asking them to get a kid help is a pretty drastic action. And that he did in fact do that. And he gave them the list of places to call. He testified that when they entered the room, Jennifer Crumbley didn't greet her son. Jennifer Crumbley didn't hug her son. Jennifer Crumbley didn't engage with her son at all in the entire 11 minutes she was there.
Oh, 11 whole minutes? That's how concerned the school was about his actions. They gave 11 whole minutes. Now look, Law Rack's confessions here. My mother, during the course of my 12-year elementary education, made more than one trip to the school in the middle of the day to deal with me. And during every single one of those trips, there was suspensions for fighting. There was suspensions for just me being a dipshit. There was other problems. Each and every one of those times, my mother came to the school. That's exactly what she did. She didn't hug me and go, oh, my poor baby that's in trouble and concern. No, my mom came there, stood in the door, and gave me the stink eye. She gave me the just wait until we're out in the car and nobody can see. Then we'll talk. That's the look mom gave me. She listened to the principal, took the suspension sheet, took the whatever form she had to give and sign for. She handled that, thanked the principal, and walked out. I honest to God, no lie, do not remember my mother saying a word to me anytime she came to the school. Except for the first time when I was in first grade and I was swinging on a tree branch from this really old tree and I broke the tree branch. And she was good friends with the principal, so she felt free to cuff me upside the head and tell me I was going to get it from dad, because dad and the principal were kind of best friends. So that is honest to God the only time I remember my mother saying anything. But anyway, that little bit of a diversion there. But to somehow be like, why she didn't care about her kid because she didn't hug him and offer, nah, she was probably a pissed mom.
And we know she wasn't going to be in that school very long because she'd already told her boss she'll be back by 12 or 12:30. Doesn't leave a lot of time for the meeting at the school. It's a 20-minute drive. Sean Hopkins will tell you that what he felt mostly in that room for the shooter was compassion.
Yeah, I know. My sister is a second grade school teacher. She tells me some horror stories.
And also knew mom and dad decided, no, we have to go to work. They said that in front of their kid. He knows very well what they do. He knows his dad works for DoorDash. He knows his mom and her ability to work flexible hours. She worked at home, but they left. She did not hug him goodbye. She did not touch, or even acknowledge him. And we know now from her testimony,
Wait,
we know why.
the school didn't send him home?
She was mad at him.
They just brought her in to say your kid needs help?
Done that, and she thought this was a discipline thing, and she was very angry.
Didn't send him home for the day. All right, that's
We
weird.
heard from Nick Ejek. He's the dean of students. He also testified and corroborated what Sean Hopkins told you, which is that the meeting was called. They were concerned about a mental health issue. They told mom and dad he needs services. Here's a list of the services, and they defended the Jennifer Crumbley was irritated by it. In fact, when she walks into the room, she doesn't sit next to her son. She goes back here and stands. And that meeting ended with her saying, "Are we done here?" They're consistent about that.
So
Nick Ejek testified he didn't think there was any risk. I don't like what he said, and I knew he was going to say it. But it's not my job to put witnesses up here and only say things that I want them to say that helps my case. It's my job to present evidence that's the truth, because you have to know the truth.
all right.
Joseph Bryan is the first law enforcement that had contact with Jennifer Crumbley and her husband right after the shooting. And you saw the interview in the substation. And you saw the demeanor of the defendant. I want you to remember something. It wasn't even an hour. We were around an hour after the shooting took place. She's on her cell phone. She's looking to see if it's on the news, she said. We also know that there were deleted messages. We don't know when she deleted them, but we know there were messages deleted after the time of the shooting, from the time that the phones were seized later that night. He asked about the gun, and you heard what she said, what they both said. It was hidden. It was hidden.
Okay, so it's
She
hidden.
read the text message. Oh, he said he loved me. And she reads the text message. And then she said, I texted him, I love you back. It was 49 minutes later that she texted, I love you back. And it was
So?
after she already knew that he was the shooter.
Oh, that's a problem. I mean,
She
not a
doesn't
problem
say
that
what
proves
the
her
text after
guilt.
that is. She leaves that out. The text after that is, Ethan, don't do it. She doesn't say, well, we were at the school, but he was also caught searching bullets that night, the night before. She doesn't say that, and I told him, don't worry about it, just don't get caught. She doesn't say that they had just purchased the weapon and it's not secure. What do they say? The very first time they are asked about what Jennifer Crumbley's asked, where was this gun? The very first time, what did she say? It was hidden.
So?
She
So
does
is
not say there was any locking mechanism at all, and neither does James.
did they ask him? Did they
You're
ask if
at
there was a
the
locker
police
mechanism?
station. Your son's in the next room. You know the murder weapon was the weapon you just purchased for him. And when you're asked where it was, you say it was hidden.
Why is this a problem? I don't get it.
We also heard from Andy Smith.
Why is that a problem? That the gun was hidden? I think that's a good thing. And they asked where it was, not how it was secured. So where is the gun? It was hidden. If they asked, was it secured or how was it secured, and said it was hidden, that might be a little more interesting. But she answered the question. Where was it? It was hidden.
Jennifer's boss, he testified she could have absolutely gone home. She works from home, and there's flexibility, that they have kids that come to work, that the meeting that she wanted to get to was not in any way mandatory. And he testified about some very bizarre communications. He testified that as soon as she left, he got a text saying, my son, the bullets are gone, the gun is gone. He must be the shooter. Oh my God. Those were deleted by Jennifer Crumbley. We don't know why. I think there's a lot of circumstantial evidence to suggest why, which is those are statements you don't want on your phone.
Yeah.
And then, not 3 hours.
It doesn't prove that she's
after
guilty
her
of
son
anything.
shot and killed 4 people, and he's already in custody, and it's already clear that he is probably never, ever, ever going to be out of prison for the rest of his life. She's texting, don't judge me based on what he did. I need my job. Her explanation for that, she was in planning mode.
Okay.
The next witness is Amanda Holland, who testified that she came back to the work that day. She had the worksheet. Andy Smith also said she before the shooting occurred, she was down, she was sad. I feel like a failure as a parent.
Said every parent of any teenager ever.
And she also tells Amanda about this, and she tells Amanda he can't be alone. So I'm just going to take him to the barn tonight. We can get to it a little bit later.
This is so weird to me. How does this prove that the mother had a duty of care to perform or not perform something, that they neglected that duty? So if you're going to say they had a duty of care because their son had a gun, well, it seems to me she trained him how to use it, took him to the range. It was hidden from him. This is strange. And he can't be alone. Well, that's what she said. She can't be alone, so I'm taking him to the barn. She didn't leave him alone. They haven't shown how she was negligent. Deleting text doesn't show that she owed a duty of care or was negligent to somebody. All right. She's got to tie this together because it's not coming together for me. She's halfway through. She's halfway through her closing, and I haven't seen a single tie to the elements of the crime yet.
I guess what's really hard to comprehend is how before the shooting, just based on the meeting and what she knows and the drawing, she thinks she's a failure of a parent.
Okay, there's a
She
drawing.
sat right here and said, after all, she doesn't really think she was a failure as a parent. And that's after she knows everything that happened. Detective Adam Stoyak executed the search warrant at the defendant's home. I want to make it really clear. Jennifer Crumbley is not being charged with involuntary manslaughter because she has a dirty house. That's absurd.
Then why bring it up?
Pictures so we can prove that she didn't have her house clean. I don't care if her house is clean or not, and I don't think you do either. Those pictures are shown to you because that is where the shooter lived and it's where she lived. And you saw his 2 bedrooms. There was barely a place for him to sleep. The testimony shows he had no person in his life after that friend left. He was not in a club. He was not in sports. He wasn't working. When I see those photos,
He was 14 or 15. Why he shouldn't be working?
yeah, 2 rooms that were completely filthy, dusty, covered.
Wait,
with clothes
I thought that
everywhere.
didn't matter.
But then I think, what? That is where he spent 99% of his time. It's
Like
where he
every
went to
teenager
the-
ever.
Just days before the shooting. The search warrant photos were also shown to you so you could understand where these guns were stored. We have a pretty good idea that the Kel-Tec and the Derringer were in what's called the gun safe.
Okay.
The lock was 000, but we know that they were kept there. What do we know about the safe? The Jennifer Crumbley's son's gun. We know that there was a box on the bed and the ammunition next to it. This is the box. This is the box. I'm sorry, this is the thing. Let me get that over there. He's going to show you in a minute. This is the box of the Kel-Tec, which was found with this cable lock inside of it. Where she kept the other guns? No.
I'm sorry, is that the box or the key? Is that the box or the safe?
This is the box.
Wait, what? So the defense lawyer is just interrupting without even an objection. She's just asking questions. All right, that's kind of weird.
The other guns? No.
I'm sorry, is that the box or the key? Is that the box or the safe?
This is the box. What's the box? It was in the kitchen, in a cupboard, down
Sorry.
in the
But
cupboard.
the empty box was in the kitchen, right?
What is it?
Your Honor, this is my closing argument, and I would just like to finish, please.
Sure, can you tell us what exhibit number it is?
Yes.
This is so weird. All right, that's weird. This is my closing argument, and I'd just like to finish, please. Well, she shouldn't have been asking that question anyway. Okay, that was a weird exchange. The judge doesn't tell either of them to shut up. The judge interrupts the interrupting. All right, that's just kind of weird.
It is 35.
That's weird.
This was found in the kitchen, inside.
I thought it was found on the bed. Wait, I'm confused. I thought she just said she found it on the bed. The safe was on the bed. That was in the kitchen. All right, I'm caught up here.
This was found on the end of the defendant's bed.
Okay.
Special Agent Brandon showed you what it's like to open this up and close it. You hear that, Todd? It's not an easy thing. So what this is.
What do you mean it's
laid out
not
on the
easy?
defendant's bed,
You dick.
and the bullets are right next. The box of the ammunition is right next to it, empty. The story, one of these stories that is told by Jennifer Crumbley is he must have come in there when they were sleeping because she was in that bed all night long, and they left after her. Except that the ammunition was in the box. Taking it out and leaving the box while your parents are sleeping doesn't make a lot of sense. And it doesn't make a lot of sense that this
True.
was taken, the weapon was taken out of this case with no one hearing while they were sleeping. And you are allowed to use your own common sense. He also testified about the search warrant. He testified where this cable.
Wait, so where was the gun? Was it in the unlocked box on the kitchen table, or was it in the locked box under the parents' bed, hidden? And if it was in the box, the empty box on the table, I don't think the law required at that time that the guns be locked up. So it's not a crime to be there. And where was the box before it was on the table? Was that also under the parents' bed? I got a lot of questions about that. So people are saying nobody knows where the guns were. The kid already had it. How do we know that? Did they prove that? Because I think she should have mentioned that in closing arguments if she knew where the gun was before, where the box was, which box it was in, where that box was, and how he got a hold of it. They should be able to prove that.
The lock was found, and he testified where the case and the box was found, and he testified where the gun safe was found. It was not, unlike what Jennifer Crumbley alleged, stored separately from the ammunition. It was actually right next to the ammunition. In a gun safe, the other two guns with a combination 000.
So what if the combination was 000?
Arrives at the scene, doesn't know anything about the Crumbleys, doesn't know that they've already been to the substation, doesn't know that they were at the school that day. He's there and was ordered to be there to keep the house safe while they are waiting for the search warrant. And in doing so, he needs to keep the defendant out of the house. She goes in the back of the car, and you saw the video. She now tells Sergeant Pesky she actually never really looked closely at that worksheet. Now that she looks at it, it might be disturbing. We know that's not the truth. The question is why she's lying. She says that the .45 caliber gun used at the school, and he asks if it was, and tells him no, it was a 9mm. The other was a 22, I think. She said that they had a fight the night before with her son over grades. And she says, so we told him, no gun range, no phone. Those are his trigger points.
Oh, yeah, phrasing.
Ladies and gentlemen, that phone was never taken away from her son. We know that. We
So?
know that because he had it the night before, and he had it at the school. We know that because when Jennifer Crumbley was asked about it, and asked, when did you take this phone away? We know that he made that video in that shed about the school shooting with his phone at 10 o'clock.
Okay.
The phone was never taken away. Why is she saying that? I don't know. Then
So
she
what?
says, my biggest fear was that he turned the gun on himself.
But was the gun taken away? Okay, so she didn't take the phone away. Did they take the gun away? And did he somehow, find it and remove it from wherever it was? The mother said it was hidden. And I guess I'm kind of getting ahead of myself here because people are calling me out, saying this isn't about common sense. Unhung Hero says, I love how you're analyzing this show trial like she has a chance. Thank you so much for the support there, Unhung Hero. And Renee Miaz says, hi, y'all. Hide your nudie mags because the state will convict you of grape if your son sees them and then commits the crime. This is absolute bullshit. They're not making their case. So if just based purely on the closing argument, I still haven't seen a single element of the crime established. Not a single element yet. And that dog in him, thank you so much for the super chat. Sorry for the 15-minute delay in getting to this, but the dog in him with the $10 super chat. So the parents have either to train and practice how to do what the son did, or the son had no thought of self, and by order of the parents did do what he did. Can't have your cake and eat it Tuesday. Yeah, see, that's the thing. As I said at the beginning, it's just weird how they're arguing both theories of the case. Either she was grossly negligent in performing an act, or she was grossly negligent in not performing an act. They're saying you find either one of them. I find that really strange. Either find that she did something wrong, or she didn't do something which was wrong. Whatever. Whatevs. I don't get it. And John Gary, the counselor, apparently suggested they take him home, but they didn't want to. It doesn't seem like they pressed the issue, which might have given them a false sense of security. Very likely. All right, let's see if they ever get around to tying this into the argument. Like people are telling me that it's not supposed to make sense. All right, I'll trust you because it's not making sense to me at this point. And I'm upset at those of you that told me to watch this because my blood pressure is starting to rise.
And when he asked her, do you ever keep guns in your car? Here's what she did. Shook her head.
Okay, so she said
That's
no.
not what she says here today. Next, we heard from
Okay.
Bob Patelis, who processed the scene. And you saw those pictures, and they were hard to see. He told you that there were 32 fired cartridge casings. He collected all that evidence, took all the photographs, and recovered the murder weapon.
Okay, this is going to sound horrible, and I'm apologizing in advance for saying this because it sounds really horrible, and I know it sounds horrible. But they're arguing that he was a trained killer. He trained on the gun range, apparently for almost a year. They're saying he was in the stance. He picked his targets. He took shots that nobody else could take. Yet he fired 32 shots and only took out 4 people. That doesn't sound like he was trained very well. I know that sounds horrible to say, but it sits like a contradiction on me that he was this highly trained assassin and his mother facilitated, but yet didn't really hit much. And I know how that sounds, but I think you know what I mean.
Lieutenant Marsvan was also at the school that day, and he testified that he picked up the phone and saw the screen and saw that the last text was, "Ethan, don't do it," from Mom. He executes search warrants for all of the devices and the home and sends a team, including Officer Keshke, to secure the house before the search warrant is executed, which is what they do. He testified that when he went into the house, he finally got there and he needed their phones. And he testified that Jennifer Crumbley said, "No, I don't want to give you my phone. I'm not giving you my phone."
Good for
She
her.
finally relents because her husband says they're going to get it either way. And then
They should have waited for him to get it the other way.
She doesn't want to give the phone up.
Good for her. Smart woman.
But the most important thing that Lieutenant Marsman said is when he described how he had to identify the body of Hannah in Madison that day.
Been there, done that. Asked an interesting question. Who had more gun training, this kid or Alec Baldwin? I would say Alec Baldwin had way more. And this is a true story. You can look this up. Alec Baldwin's father was a legendary high school shooting coach. He was a shooting coach at a high school. Dude was so into Alec Baldwin's father was so into shooting and training shooters that he legit died of lead poisoning. So yeah, Alec Baldwin probably had way more training than this kid did. That's actually a fact. Check it out. Cause of death for Alec Baldwin's father.
Dave Hendrick is retired, but he's the former sergeant in charge of the fugitive apprehension team we call FAST. And his job, his only job, when he was doing that, is to find people who have felony warrants and haven't turned up. He has a lot of ways to figure that out. But he was asked to find Jennifer and James Crumbley to make sure they turn themselves in. But one of the other primary goals he has is that they turn themselves in safely. And she was given every opportunity to do that, and she did not. I want to talk to you about something. The judge is going to instruct you that you can consider flight. It's not an element to the crime. I don't have to prove that they fled. The reason we introduce this evidence is she's going to instruct you that you can use that as a sign of consciousness of guilt. What do you do if you know you've done something wrong? You can use that to show consciousness of guilt. And we're going to get to it, but I believe we have shown that beyond a reasonable doubt.
Consciousness of guilt. That's what you've shown.
That the defendant with her husband immediately began to avoid detection because they're pulling cash out. They're pulling cash out of their son's bank account. They're pulling cash out of their bank account. Where's their son during this time? He's at Children's Village being arraigned with his court-appointed lawyer, where they had the opportunity to go see him, where they had the opportunity to go to that arraignment, and they did not. Because they never even went, they fled their house and went to a hotel, and then they ended up at an extended stay, and that is where they ultimately left one of the Kias backed into a parking space.
All right, that is kind of weird. I'll give her that. That is kind of
He
weird.
eventually did apprehend the defendant. You've heard a lot about that.
And if you get that,
He's gonna
oh,
tell you that there were
yeah,
hundreds
it's
of law
evidence of
enforcement
guilt, a
officials
guilty
on the scene
mind.
when
Guilty mind of what? You still have to prove that they did it.
Luke Kirtley, I know you will not forget him, coincidentally knew a lot about cars and coincidentally pulled into that parking lot right about the time and coincidentally had just seen the wanted poster, he called it, and with a description of the cars and a photo of the defendant. And coincidentally thought, maybe that's the car. And you watch the video where he goes around and he sees the license plate and he
Yeah, that dog in him. That's a great question. Thank you so much for your super chat. Why would anyone assist in your case against themselves? Right.
He describes to you how within minutes, police officers arrived and then swarms of law enforcement arrived, SWAT, the marshals, ATF, the sheriff's department, Detroit PD, all sorts of law enforcement show up immediately. He also testified that the unit where Jennifer Crumbley was actually found was very close to his and it faced the parking lot and the whole wall was windows and it was on the first floor.
So it's like any other hotel on planet Earth.
With law enforcement, lights, sirens, all kinds of things. Next, we heard from Captain.
Every hotel just has a door and a giant window.
He got there. They took a 35-pound ram to breach the door, which was right outside the unit where the defendant was found. We heard from Brian Deloche. Also, didn't love a lot of things he has to say.
I missed it. If it wasn't a hotel, what was it?
And the
I
truth
missed
is,
what it was.
like it or not,
Apartment,
this is
hotel.
Jennifer
That's
Crumbley's
standard though.
assignment.
Front door, window.
She told him that
Is it-
night, the gun's in my car, and I'm afraid my son's going to do something stupid. Before the shooting, the same day.
Oh, a warehouse. All right.
You
Whatever.
also learned
Huh.
that
It's kind of a
although
weird place to be,
the
but whatever.
threat in general was always deleted.
All right. Thanks, guys.
After the,
Thanks for
shooting,
correction.
It remained, except she deleted, not unsent. Rely on your own memory about what that testimony was. Those were not unsent messages. They were deleted, and you heard Ed Grosky tell you that. But these were the two that were deleted. On the run again, and we're fucked.
Hey, Alabama Rose. What's up, Rose?
Testified what was found in the building and the art studio where Jennifer Crumbley was found. You saw the photographs. You learned that there was a little over $6,000 in cash. You learned where the phones were found, and the cash, and the purse, in the plastic tub, in another plastic tub with the lid on it, far away.
That's actually a very interesting question.
Feet away from where
Right.
the mattress was, and there are other things where you learned all those phones were off. He also testified what else was found.
I would certainly argue they don't have the duty to do it, so you shouldn't be able to argue it.
Bananas, socks, blankets. And that is the room where Jennifer Crumbley was ultimately apprehended.
Oh well, she was apprehended in a room that had socks and bananas in it. Okay, now I know why the jury voted guilty. Bananas and socks. What is she talking about? Warrior Biatch, thank you so much for the super chat. We are now like about $52 away from dog cam. Hey Jeff, I know this isn't precedent, but what does this do to future cases involving other states' courts? I would love to see how they deliberated. Love you. Well, thank you so much, Warrior Biatch. And other states are going to take, especially the more left-leaning states, are going to take a cue from this, and they're going to go, it worked there. We're going to see if it'll work in our state. This is the definition of a slippery slope case. So it worked here. They're going to try it in another state. And then they're going to try it in more states. That's what's going to happen. And then it's not going to be just guns. It's going to be cars. It's going to be, motorcycles. It's going to be you going to the mall unattended. It's coming.
You heard from Lieutenant Phyllis, who was the officer in charge. He told you what it was like in the school that day. He described the autopsy protocols that were done and how each of those kids died and where they were shot. He told you that both Justin Schilling and Madison Baldwin were shot in a contact wound, which means the gun was either very close or actually touching their head. He showed you the video of the shooting. And again, this is not to incite emotion. The The video of the shooting shows Jennifer Crumbley's son taking a stance he clearly knew how to take and was trained to take. And you watched his demeanor and the calculated, cold way he proceeded through those hallways looking for people to shoot. You saw the surveillance of how he ultimately surrendered. Walked out after executing Justin Schilling, laid the gun on the waste paper basket, laid it safe, took the magazine out, and surrendered. We showed you and introduced the bank records that show you what they were doing after charges were either very soon coming and after they were announced. And he showed you an in-car video of Jennifer Crumbley and her husband, who just a few hours after the shooting embraced, kissed, whatever happens, I love you. Don't say anything to the police.
Smart person. That's the correct thing to do.
One of the elements we have to prove is what a person using ordinary care would have known about whether or not there was a situation that they needed to exercise ordinary care. So the defendant's knowledge of—
Okay, first of all, I don't think they've shown that they had a duty to the victims. I don't think they've shown that the mother had some duty to protect other school students from her child. I don't think they've shown that. I don't think she's even really sufficiently argued that point. But I mean, let's just give her the benefit of the doubt that every parent owes at least a marginal duty of care to protect other people from their minor children's actions. Okay, let's you say, Brennan, let's be generous and assume that's a common sense thing, and we all just know that we kind of have to try to protect our people. We have to try to prevent our child from doing bad things to other people. So now they have to show that. This is weird.
about whether or not there was a situation that they needed to exercise ordinary care. So the defendant's knowledge about her son matters.
Yeah.
But it's two different stories. It's what she knew before the shooting.
So did she know that she had this duty? Did she know that her son posed a risk to other students? That dog in him heading out, blood pressure is rising due to this. Oh, stick around. Don't leave me hanging here. Don't leave me alone. Now, in all fairness, we're going to go after the defense in the same way we're nitpicking here with the prosecution. But the burden of proof is on the prosecution. But so far, I don't think they're moving. They're making it. But now I guess she's going to address the fact that they have to show that she knew or should have known reasonably that her child was posing a risk to other people and had a duty to prevent that. I think that's where she's going with this now.
And it's what she knows, what she said she knew after. Before the shooting, she tells Kira, my son's weird. She always refers to him as an oopsie baby. She tells Amanda how.
Oh, good God. Oh, good God. Every person that's ever had a teenager in their life has described their children as weird. Now, nothing positive about him. That's a little bit mean. An oopsie baby. Yeah, well, my nickname for my little brother was Accident for most of his life. He was lonely, hearing things around the house. I'm a failure as a parent. Interesting statements about your child.
He's hearing things around the house sometimes. She said, I'm a failure as a parent. The message to her son's friend's mother, he's kind of depressed in April. She texted that.
Oh my God.
From
Okay.
her son. The messages in March about these scenes.
Every parent thinks their teenage child is kind of depressed because they are. Kids are depressed.
I think you really need to
Was it
consider
a
whether it's
dangerous
female or
level?
boy.
It was like, holy shit, he's like
Did
dangerously
you at least
depressed.
answer me or reply to my text as a joke? And we know there were no replies. There were missed calls. He called her. There were no replies. And she told us why. He was just messing around. But after the shooting, in the in-car, we hear her say, he's never been in trouble. He's never done anything. He's never done anything wrong. He's a good kid. Also in the in-car, I never even thought like he would have any mental issues. Like he never.
Now look, those are not mutually exclusive. My kid's a little bit weird. He's a little bit lonely. he's kind of depressed, not clinically depressed. He's kind of depressed. He does dumb shit sometimes. That doesn't mean he's ever been in trouble. That doesn't mean he's ever done anything wrong. That doesn't mean that they have any belief that he's suffering from an actual mental illness. I mean, these are not two mutually exclusive things. Both can be absolutely true.
Never exerted any type of anger. He's never exerted anything. He's just like one of those mellow, laid-back kids.
It can be
In
true.
the substation, he's never done anything. He's never done anything bad. After the shooting to Brian
Why-
Lowe, she's never done anything wrong.
Why can't that be true? My kid's weird and didn't do anything wrong. Can be absolutely
There's
true.
a lot of things about that drawing in that meeting at the school. She sent the drawing to James, and Kira and Andrew, as I said before, with the call now, emergency. She told Kira he couldn't be left alone. She tells Andy she needs to get him counseling, and she tells Amanda that the drawing was really scary. She agrees. After,
Okay, I'm going to keep this going here for a little bit, but while I'm doing this, can someone explain in as much detail as you can in the space allotted here what this drawing was, and then I'll talk about it in a second because I'm not sure what this drawing was.
this is what she says in the substation. Nobody didn't seem worried about it, and he said that my son's more than welcome to stay at the school, or he could go home. And I really wish we had taken him home. In the in-car, she said, I didn't even look at that closely. Now that I do, when I was at the substation, I looked at it closely, which we know is not true. I looked at them closely, and they're a little disturbing. Well, they're very disturbing because look what he just fucking did. And then to Malo, she says, the school was very nonchalant, but the paper they showed me had all of the things scratched out. That's just not true. It's just not true. And you don't have to believe me because we have evidence it's not true. And you heard it.
That's a big ass ring on her finger.
The statements about the gun are also numerous. She said, we've heard her testify the gun was in her car.
All right, real quick here. So thanks. It seems that there was a picture of a gun, a person, and lots of blood everywhere. Potentially criminal Sean, $2. Thank you so much for the super chat, brother. Yeah, the Detroit Free Press interviewed the jury foreman. I saw that. She sort of looks a little Nosferatu-ish. And she was saying that it sealed the deal because the mother was the last adult to have the gun, which, as I was talking with Megan Fox earlier today, simply isn't true. From what I understand, the last adult to hold that weapon in their possession was the school principal. It was in a backpack that she decided not to check into. So, yeah, it's not exactly true. So thank you so much for that, potentially criminal Sean. So we've got this picture of this gun, a person, and blood. All right, now this is a generational thing. I got an F in my honors English 11th grade honors English class. Certainly not for the whole term. Just on one assignment. It was an assignment to write and illustrate a Christmas story. Because also, I mean, a lot of those descriptors that were used to describe her son, weird, lonely, not engaged. A lot of those could be used to describe me. And I wrote a story. My Christmas story was about how Santa was oppressing the elves. So all of the elves in the workshop, they stopped building the toys for the little boys and girls, and they began a weapons factory. They armed themselves with the automatic weapons, and they went and they committed a coup of the North Pole, taking out Mrs. Claus, blowing away all the reindeers, and eventually gunning down Santa Claus in sort of a scene that was reminiscent of the final battle in Scarface. And then the elves took over the North Pole, and it was all illustrated with lots of guns, lots of North Pole figures bleeding in the snow, etc. I just got an F on the assignment. But now, holy shit, I never would have darkened the doorway of another school again, and I probably would have been locked up for that story. But yeah, I know Weird Al's song. It's a good song. So yeah, That's a generational thing. It was sort of, the elves sort of went, Cuban Revolution. It was a good story. I liked the story, but the teacher didn't like it so much. And it wasn't an F because it was just an F because it wasn't in line with the expected holiday spirit. But yeah, I'd be locked up. I'd be kicked out of. I'd be expelled from school instantly. I'd be put in therapy. They'd riddling the shit out of my body. I'd be doped up, and I'd never see the light of day again. So this is a generational thing, which I'm trying to keep my mind in the modern day and not comparing it to life 40 years ago.
We know that she's acknowledged that she drove to the gun range. There was no lock on the gun when she drove there. She returned with the gun. There was no lock on it, but she said James locked the gun when he got home. She didn't see him do it. She testifies at trial. James is responsible for the gun. In the substation, though, when asked where the gun was,
I thought it was funny.
in the in-car interview, James flew home and he's like, I had the gun hidden and I told him where I hid the bullets. He asked whether she kept the gun in her car. She shakes her head no. And she tells Veloce after the next day, we had the string lock on it. It came with in the case. Everything was secured, not loaded, bullets stored separately. Oh my God, oh my God, oh my God. That is not what she says in the substation.
Okay, a little contradictory.
Jennifer Crumbley begins distancing herself from her own responsibility about the gun. You heard her testify that they wanted to get the gun.
Look,
It was my son.
that dug in. Thank you.
My son did a lot of research.
Look up
on that.
viscera
Guess I was
cleanup.
dumb. Guess I was
Same
dumb.
premise.
She doesn't say she didn't know. She doesn't say
Okay.
that she didn't approve. She says it really interfered with going to get Christmas trees. That was what she was upset about. And she said it's James's responsibility. However, as I've shown over and over, at the substation and in the car, it's we.
Oh, cool.
We take him to the range. It's our hobby.
Janitorial
We go to
simulation.
That's what we do. We just got him this gun. Sitting here today, it's all James' fault. It's not ours. And then, of course, the statement.
This raises a very important question. They're charging both parents with essentially the same thing. Now, because this involuntary manslaughter deals with your own personal negligence. This isn't like where you have two people that could have committed the same murder and they're testifying against each other, or they convict one person, they hold the trial separately, and they convict one person and then they try another person for the same murder. This isn't nearly as controversial as that, because this deals with personal negligence, whether the person's own negligence rose to a criminal level of negligence. So it is absolutely impossible for two separate people to be charged with involuntary manslaughter for the same fact pattern. I don't like it, but it's absolutely problem-free.
That
In my never to be humble
we don't
opinion.
really have to question whose weapon it was. Jennifer Crumbley posts Ethan and James Crumbley both got handguns this week, testing them out at the range. That's in June. The evidence really shows that the shooter owned two guns. But for sure, she acknowledges Mom and Sunday testing out his new Christmas present. You heard evidence that was presented to you about the journal that was found in the bathroom by the shooter's backpack, right before the bathroom that he exited and started shooting. I have zero help for my mental problems, and it's causing me to shoot up the fucking school.
I have zero help for my mental. This is the kid's journal, page 6. For my mental, I have zero help for my mental problems, and it's causing me to shoot up the fucking school. Are we? See, I have a problem with this. Are we to assume that parents now have a legal duty to find and read their children's journals and diaries? Are they saying they were negligent for not prying into their child's private life? I don't like this piece of evidence one single bit. I don't like this. I'm assuming they didn't prove that the parents had any idea what was in the journal. I mean, I can't imagine how much of my shit I would have lost if my parents would have touched my journal as a kid. That's just sort of an unwritten rule. You don't pry into your child's journal. So I mean, were they aware of it? Now, does this mean we now have a legal duty? Do we all have a legal duty now to seek and snoop out every single piece of information that our child has written down, stashed somewhere, is contemplating? Don't like this.
Next slide. First off, I got my gun. It's an SP 2022 Sig Sauer 9mm. The shooting is tomorrow. I have access to the gun and the ammo. I am fully committed to this. So yeah, I'm going to prison for the rest of my life, and many people have about 1 day to live.
Okay, that's pretty fucked up, but did the mom know about it?
When you go back in that room, is why, after hearing that there's an active shooter situation and knowing that your son is involved, you are taking the time to delete text messages.
Who knows what the hell someone would do if they found out their son just murdered a bunch of
Again.
people?
Helicopters, not sure where to. I'll message you, and we're fucked. Deletes. The gun is gone, and so are the bullets. Oh my God, Andy, he's going to kill himself. He must be the shooter. Ethan did it. Those were deleted from her phone.
So I can see you sending that and then go, "Ugh, this doesn't look very good. I better get rid of it," and not thinking, "Oh, I'm destroying evidence."
She deletes all the things she says about the drawing to Kira, including.
Hey, MG, what's up, brother? I completely agree with you.
This is a timeline from when in March, which you've heard a lot of testimony starting about March, was where we first have evidence that he was struggling, he was hallucinating, he was seeing things, and he wanted her to text back, and she didn't. We know that he had some incident, and he said that the mental breakdown in April. You saw text messages between James and Jennifer saying, did he say anything about last night? He woke up in our bed, he didn't know where he was. We don't know what that was about, but we certainly know that is not evidence of somebody who is completely fine and stable. In fact, lots of messages from Jennifer Crumbley saying, I'm worried he's going to do something stupid. In April, she texts her friend that she thinks he's depressed. The Caltech and the Derringer was purchased in June. They go to the shooting range in June. They go to the shooting range in August. They go to the shooting range in September. And then in November, they buy the Sig Sauer. And we see the shooting range that Jennifer Crumbley went to with her son, testing out his new Christmas present. Here's what we learned Jennifer Crumbley did after the shooting. As soon as they took her phone, they bought.
I'm going to say that in the grand scheme of things, what she did after the shootings has little to no bearing whatsoever on her legal culpability for the murders. Other than, as they said, it's the evidence of a guilty mind. What she did after has no direct bearing on a charge of manslaughter, of involuntary manslaughter. So this, as far as I'm concerned, you can pretty much just chuck out the window. Anything that she says about anything that happened after the murders. Was she criminally negligent before the murders? That's the question. Unless one of these things she did after was go, holy shit, I completely fucked up. I gave him this gun and told him to go blow away some people or something to that effect. Unless she says something directly incriminating her as being grossly criminally negligent, this is all complete bullshit.
Burner phones in the pier at 8 o'clock the night of the shooting. They checked into a Holiday Inn Express that night in the pier. They then left and went to an extended stay in Auburn Hills, which Lieutenant Wills testified was almost across the street from a police department.
What is this shit?
Learning that charges were possibly coming, and the same day charges were announced, they leave that hotel and drive to Detroit. They withdrew 2,000
Okay, I'd probably rather go to jail than go to Detroit, but that's just me.
from a Flagstar Bank at, on December 2nd. They drive to Owasso, an hour away.
Right, MG,
She
right?
says because we just didn't want anyone to recognize us to buy replacement phones. She texts.
Everybody needs to go check out MG Law, by the way. Great guy, horrifically undersubscribed.
At 7:31 a.m. on December 2nd. She texts on December 2nd, we're fucked at 2 o'clock. On December 3rd at 4:59 a.m., she texts, I'd rather die than go to jail. Then she withdraws $4,000 from another Flagstar on December 3rd. She checks out of the extended stay on the 3rd and drives down and arrives at Bellevue at 10:58 on December 3rd.
How is any of that in any way remotely illegal? Now, if they were avoiding arrest, if they knew there was an arrest warrant out for them and they were doing this, then they would be in some, but nothing they did there is in and of itself illegal.
You heard what happened. You heard her testimony. The facts do not support the story that Jennifer Crumbley told you. They just don't. There is no
So?
possible way. And
Okay, but your story has to establish the elements of the crime. Keep that in mind, dear prosecutor. And she's coming down to the end of her argument here.
Corporal Shaw, that you could be in that building with that many law enforcement and not know that somebody was there. And we don't even have to use that place testimony, ladies and gentlemen, because she texted herself. I think we're caught. We're laying low. She texts that, we find out, and this is evidence we got this morning. She texts that after she's already said she took 4 Xanax and went to sleep.
Do you blame her?
You saw that video. All those people for over 2 hours, they're sleeping, and even when they come into the room, they still don't even act like they get up. It's just not true. And we know it's not true because they'd already taken steps. She had hidden the phones, powered them down, separate from all the other things they had with the cash.
Okay.
Jennifer probably wants you to believe that if only the school had done something different, we wouldn't be here. If only
Well-
the school. Well, let's talk about what
That's true.
That no school employee knew. She knew about the text messages in March that he was about a demon, throwing bowls, clothes flying off the shelf. She knew about the March 18th incident of waking up in his parents' bedroom and like he had way too much to drink and asking why he was in their room. She knew he had previously asked for help.
All right. Before we read this, I want to read through these like calmly and quietly here. But first, Hempland, Texas, Hempland TX in the house with a $20 super chat. They proved to the world what horrible parents they were, and they should have cleaned his room, but that does not prove he knew beforehand. Right. They prove she deleted most text messages all the time. Yeah, I believe there was some testimony that she just kind of went through and deleted everything regularly, which, you know, bless her, I wish I could do that. Lock up your butter knives, parents. It's a slippery slope, and I don't like it. I don't like it at all. But Hempland, Texas, the one thing I do like is she's brought us to the point where we're at the point in the show that we call
Release the hose.
where we've unlocked dog cam for today. First time in a very long time. There we go. They're sleeping peacefully in front of the space heater here. We've got the space heater. They're just enjoying the hot air being blown out of there, unlike the hot air that's being blown out of the prosecution at the moment. So let's read through these here. March 9th, 17th, and 20th. Texts about a demon, the demon throwing bowls, clothes flying off the shelf, etc. I'm the wrong one to say that to, because I've had experiences similar to that, which, you know, I probably just had 300 of the 378 of you watching think now I'm certifiably insane, but I've had some demonic poltergeisty experiences, and we didn't have text messages. I had to call my mother and tell her, and she just kind of laughed and told me to stop being a dick and hung up on me. But so that's not as crazy as it seems. March 18th, incident regarding her son being worked up, giving him melatonin waking up looking like he had way too much to drink, asking why he was in his parents' room. Okay, so all right, so they gave him some melatonin because he was worked up. Her son previously asked for help. Did he though? I heard he didn't. He previously asked for help and to go to a doctor, and she laughed at him. Okay, if that's true, that's kind of getting close to a line. There were multiple guns in the home. So effing what? So effing what? Good God, if that's a problem, Jesus. My brother-in-law's pretty much got an arsenal in his house. Son gifted a gun days before the shooting, and the gun was considered to be his own gun. Again, nothing particularly shocking there to me. In my generation, coming from cowboy country, the gun looked identical to the one in the graphic drawing that morning. The gun was accessible to defendant's son. How was it accessible? What does accessible mean? Was it accessible? Sort of like the Hitchhiker's Guide to the Galaxy, where they said, where's the plans that they're demolishing Arthur Dent's house to make way for a bypass? And he said, oh, I found them. They were at the bottom of a flight of stairs. The stairs had gone out, so had the lights, and there was a sign on the door saying, beware of the leopard. Well, but they were on display. So were they accessible because they were hidden under somewhere and he knew where they were hidden? Or was it just like, here's your gun, son, go and do with it as you please? There's a lot I don't know here. And the way they're using vague terms like accessible indicates to me they haven't adequately proven that. Because they would say there was also ammunition, which was located in this position, in the same box as the gun, next to the gun, in the same room as the gun, in his possession. I think they would have been more specific if they would have done that. Her son was proficient with a gun. They argue that, but again, and we've just learned that 2 of the 4 were taken out with point blank, which doesn't require any marksmanship whatsoever. So we take away those 2 people, those 2 shots, and that means 30 rounds were fired and only 2 people were taken out as a result of it. That doesn't sound like he was very proficient. And that's a horrible, and I understand offensive analysis to make, but they're asserting he was proficient with a gun, and it doesn't really sound like it. Her son was locked out of the house the night before. Okay, so locking your son out of the house for whatever reason, let's assume that's true. That doesn't necessarily mean because you locked him out of the house that he's going to run off and shoot up a school.
And to go to the doctor, and she laughed at him. She knew there were multiple guns in the home. She knew her son had been gifted a gun just a few days before the shooting. She had posted it on Instagram. But apparently, it's absolutely fine for all your Instagram friends to know that you got him a Christmas present with a 9mm handgun, but it's not okay or relevant to the people sitting in that room with that drawing.
That's a good point, Angelo.
She knew that gun looked identical to the one in the drawing. She knew that the gun was accessible to him. She knew it wasn't stored properly. She knew that he was proficient with the gun. She knew he had access to ammunition. And she knew that her son was upset the night before. Now, that says he was locked out. She told Amanda Holland he got locked out. She doesn't acknowledge that. She does acknowledge that he did leave the house that night because he was upset. And we all know what he did. He went to that shed and recorded that video.
I object. That video did not come into evidence.
Okay, it isn't enough evidence.
Okay.
You're right.
That's true.
Wait, what? She's talking about a video that wasn't admitted into evidence?
And record that video.
I object. That video did not come into evidence.
Okay, it isn't enough evidence.
Okay.
You're right.
That's true.
I can't hear. I know what the closed captions are saying, but it sounds like she's saying, but it is in evidence. So was this video in evidence or was it not in evidence? I don't know the answer to that. So what was the video? Okay, it was not in evidence. Okay, so the prosecution is absolutely wrong for bringing up a video that was not in evidence. Okay, so I did hear slightly incorrectly, and the closed captions were correct. That's why I stopped. Megan's back on 1.5 speed, and we're already on 1.25 speed. So she'll find out that's 1.75 speed here in a bit. So, okay. So, all right. So the prosecution was doing some shit there, bringing up a video that was not in evidence. Defense was absolutely right with that objection.
Let's go back to the elements.
Yes, let's go back to the elements.
Ordinary care. What ordinary care, the smallest, tragically smallest thing she could have done to prevent this. She could have stopped at home on the way back from the meeting. She goes right by her home to see where the gun was. She could have stopped on the way back to work. She could have searched the backpack. She could have asked her son where the gun was. She could have.
Why would you do this if you didn't have any idea he was going to? Why would you go to school and then go, oh, I'm going to go home, and your son is doing some shit, and then you go back, oh, I need to find out where this gun is. Why would you do that? Why would you search for a gun if you had no clue that he was going to use a gun to shoot up a place? That's a dumb argument.
She could have taken him to work. He could have gone with dad. He was door dashing. She could have told the school that they just gifted him a gun. She could have embraced the gun. She could have said, can we talk to him for a minute alone? She could have looked at him and said, I care about you. I love you. She could have at least
fuck off. These are stupid. This is bullshit.
About her son being in crisis previously and asking for help.
Did they ask about it? This is dumb.
Ordinary care would have included all of those things.
It would not. Oh, that's a crock of shit.
None of it was hard. None of it. The smallest thing.
That is way beyond an ordinary duty of care. Way beyond. Every time your kid gets called into the principal's office, you have to go through a litany of every bad thing your child has ever done. You have to go through a litany of every quirk in his character. You have to go into every facet of his private life. That's a stupid argument.
Just the smallest thing would have saved Hannah and Tate and Justin. And
Say their names.
The smallest of things. I have to prove that there's reasonable foreseeability. And that worksheet right there that Jennifer Crumbley saw just hours before the shooting.
Oh, okay, is that the picture?
And we're going to show you in the next slide.
Wait, okay. Was that the picture in question with the gun, a body, and blood everywhere, or was there a different picture? Okay, if this is the picture, oh my God, I can't. From the time I was able to pick up crayons, I was drawing jet fighters, blasting people, dropping bombs, nuclear bombs, dragons attacking people, people shooting other people, hunting deers. Oh my God, if this is the picture, this is it? Oh, fuck off. No way. I was expecting like a graphic picture. This is doodles. This is a kid doodling on a test or something. What does that say? It's not what I do. Blood, what? Blood everywhere. Oh, okay. He wrote blood everywhere as one of the answers. Oh, come on. Yeah, we were hunting. No, we'd like draw hunting deer all the time. Did I say deers? Whatever. Yeah, hunting deer. Oh, this is dumb. All right.
Before the shooting is reasonable foreseeability. I'm going to show you in the next slide.
Okay, now we just had a comment here that where'd it go? Yeah. Michael Krasuski says normal kids don't draw that shit. That is not an abnormal drawing. If that's an abnormal drawing, I'm lucky. Oh my God. The stuff that I drew was so much more bad than that. This is just a gun. And all right. Frustrated. Sorry. And Amber Morris, $5 super chat. Thank you so much. This is asking every parent to assume their depressed teen is capable of being a school shooter. Do we have to assume that now? That's what this case seems to suggest. This case seems to suggest That's what we have to assume. Missed super chat. Did I miss a super chat from you, Duncan, Idaho? Really? I don't think I just no. We haven't. Okay, found it. Let's go back and read this first here. Duncan Idaho says now you have a legal duty to totally invade all aspects. I read that. I think I read part of it. I don't know. Now you have a legal duty to totally invade all aspects of your child's privacy if the state decides you should in retrospect. If he does something that upsets people enough, I guess that's the law now. And to which you replied, missed super chat, not to argue against you per se, but police are well trained and also miss tons of, they are stormtroopers in that regard. When they're shooting in the heat of the moment, would need to introduce other experts for that. Yeah, that is true what you're saying, but they were making it sound like he was a sniper there. You see in the video, he's assuming the shot. He's taking other shots that normal people wouldn't try to take. They were sort of making him sound like he was much more proficient than he actually seemed to be. We got Hempland, Texas there. Just Dawn sitting in the hospital. Just Dawn sitting in the hospital waiting to go to surgery. Extensor tendinovitis in my wrist, second time. If that's anything like tendonitis, which I have the extensor tendonitis in both feet, I'm about 90% better, but that sucks if that's it. Second time, wish me luck and please have a drink for me. We can do that. I just happen to have a little bit here with me. Cheers to you, and bless you that the surgery is a success and you don't have to do a third time. Good luck with that surgery. Thank you so much for being a supporter for 14 months. And Psycho Doll X, member for 5 months. Thank you for the support. Verdict was an effing tragedy. Parents start praying for your kids don't get caught doing crimes. Who knows what you'll end up getting charged with? Well, that's where we are. And Amber Morris. This is asking every parent to assume that. Right, okay, we already read that. Thank you again, Amber Morris, for the super chat. And I think you're right. That's where we are. All right, she's about ready to wrap up here. So let's get on
That's
with
the
it.
picture of the gun. It's not just any gun, ladies and gentlemen. It's the gun that they just gave him. Blood everywhere. That's what he wrote with ammunition. I didn't show you the picture with the blood because I don't think you need to see it again. But we know what happened in that school and in that hallway. Here's a picture with 2 bullet holes and blood coming out of the figure's head. And look at that. That is where those shots went.
I mean, that is a little disturbing, but is it a trigger? Is it a warning sign that you have to go full into overdrive?
Stop. Help me.
Now that
These are
is
all
different.
of the things that were texted to Jennifer Crumbley.
Mm,
This was in March. But he's writing it on a piece of paper and he's showing it to her. That is foreseeability.
okay.
He's telling in that drawing, this is the gun that was purchased for me. Help me. Blood everywhere. The world is dead. I know you won't ever forget the video, but if you look at the defendant's son and see that there was no emotion, none. He was only concerned in a very calm manner for finding as many people as he could to kill, and he did.
And Nighthawk with a $10 super chat says, this winter, the greatest movie that graced the movie theaters named Red Christmas, The Revolution. I have not heard about that. I'll have to add that to my list. Thank you very much. And Josh with a $5 super chat. EC has been messaging his friend about losing his mind. Then EC wants a pew-pew for Christmas. Friend is like, Mom, I want to go to that OCD camp now. Thanks for the super chat. Appreciate it. Oh my gosh.
My life is useless. These statements from the defendant's son.
Oh, that's interesting, farm girl mom.
I actually asked my dad to take me to the doctor yesterday, but he said, just give me some pills and told me to suck it up. Like, it's at the point that I'm asking to go to the doctor. My mom laughed when I told her, but I am having bad insomnia right now. I need help. I was thinking I could call 911 so I could go to the hospital. But then my parents would be really pissed. Like I'm mentally and physically dying. Let's talk about the cable lock. Jennifer Crumbley says that the cable, the weapon was used, but it was locked in a cable lock that came with the case. This cable lock that came is the cable lock that came in that case with the SIG. It's never been opened and it's never been used. This is the last picture that we have of that gun until we see it murder 4 kids on November 30th. And the person holding it is Jennifer Crumbley. She's the last person that we see with that gun. She's the person that said it was in her car. Then she said it was in her house. It was her husband's responsibility. It wasn't hers. That's what she told you.
Okay.
She knew he was distraught the night before. He texted her, "I love you." She told you that's never happened before. She did think it was abnormal or odd. She knew he was looking up bullets in the school. She knew he was watching violent videos. She knew he was proficient with guns. She knew he was previously in crisis. She knew his only friend that he talked to was just gone.
All right. Well, I'll talk about it later.
She
Sorry.
knew all those things. And then her own statements, ladies and gentlemen, when she took the stand. She testified that when she's looking back, she still wouldn't do one thing different. Not one. Not any of those tragically small things. Even now, she told you she wouldn't do anything different.
Did you ask her, knowing what you know now,
We took his
or did you just ask her if you went back, would you have done something differently? Those are different
And then
questions.
she said she doesn't think of herself a victim, but she has lost everything. You're going to hear the instructions from the judge, and you're going to take the facts and the witnesses and the evidence and use what you promised to use, which is impartial, honest assessment, and find what you believe the facts are in this case. The flight, evidence of the flight and what they did after is not an element I have to prove. But what does it show? It shows the minute this shooting became public and ended up in the paper and the media, Jennifer Crumbley started telling a story and then she ran. And she didn't run just because she was selfish, ladies and gentlemen. She ran and she started deleting text messages and she started telling a different story because she knew she had done something wrong. That's the only reason you start deleting text messages. It's the only reason that you start saying something that isn't true. It just isn't true. Jennifer Crumbley drove to Detroit with a bunch of cash and 6 cell phones powered off. You can consider that as consciousness of guilt. Everything she did from the time she found out that there was an active shooter and had a 10-minute call with her husband. They both say they went right. He called 911 right away. He did not. He talked to his wife for 10 minutes, over 10 minutes on the phone before he called 911. But the facts changed because it was an immediate attempt to misrepresent what actually happened. Why? Why is a mother whose son just killed 4 people thinking about deleting her text messages? Why is she saying things that are not true about her son? Why does she care about her job? Why does she care about her course?
Why does she care about her job? What a fucking stupid question that is. But, why isn't she thinking the worst of her son? I wonder if this prosecutor has a child. The parents are usually the last to think bad things about their children. You never want to believe that your son is capable of murdering people. Nobody wants to think that about their kid, even in the face of evidence.
This lesson. Why does she care about any of these things? Because she knew she did something wrong. And she's deleting all of those things because she wants you to believe that she's somebody she's not. And you know what she's not? She is not somebody that used ordinary care to prevent what was foreseeable, reasonably foreseeable, that could have happened. Injury or death, and it did. It did. Those words on that paper helped me. She walked out of that school within 11 minutes, didn't so much even address her son. She did not give him the help that he wanted. And you can argue about the months before and the weeks before, but if you just even look at what happened that day, she walked out of that school and she knew something bad might happen. What does she do when she gets back to work? She all of a sudden texts her son, "Are you okay? You know you can talk to us." These are the actions of somebody who was worried. She was worried and she was concerned and she was panicked until after. And then it's a different story. Why? Because she knew she had done something wrong. She walked out of that school when just the smallest of things could have saved, could have helped Hannah and Tate and Madison and Justin. Just the smallest of things. And not only did she not do it, she doesn't even regret it. We have proven beyond a reasonable doubt that she is guilty of 4 counts of involuntary manslaughter. It's a rare case. It takes some really egregious facts. It takes the unthinkable. And she has done the unthinkable. And because of that, 4 kids have died. So I'm asking you to go back and review the law, review the evidence, and find her guilty, because we have proven her. Thank you.
Your Honor, I am ready to go, and I will, but I'm going to need to use the bathroom halfway through. Can I have like a 3-minute bathroom break literally? Do you guys want to break?
Okay. Okay, first of all, I have to apologize for stopping so much. Even at 1.25 speed, I turned a 1 hour closing into 2 hour closing. And her closing is actually 2 hours. I'm going to go as long as I can. I honestly, it's 1 o'clock in the morning here now. I honestly doubt I'll be able to get through the whole thing. But her closing, I'm going to boost to 1.2. I'm going to boost it up to 1.5 because from what I've seen, she tends to talk slower. We'll see if we can do that. I'll try to talk less, or I'll just talk over it. I apologize for this. But let's talk about some things here first. Jojo with a $5 super chat. Why didn't he tell a counselor he was hearing voices and seeing demons if he was reaching out for help, especially if his parents weren't helping him? That's a good question. And one, unfortunately, I don't think we're ever going to know the answer to. And Voodoo Berries with the Aussie $5. Man, if people saw the crap I wrote as a moody goth teen, all of my texts to my friends were about how my parents were the worst and didn't understand. Exactly. Now, real quickly here, how do I see this closing argument? I didn't like it. Because she didn't clearly delineate the elements of the crime. Well, she said what the elements of the crime were, but she didn't clearly state this happened, therefore this element of the crime is met. And if we look at this, the gross negligence. The gross negligence related to not performing a legal act. They had to prove she had a duty to the victim. I'm willing to concede that there is some common sense general duty of care you owe to society to generally make sure your kid doesn't do anything to endanger other people. The second element is you have to know the facts that gave rise to the legal duty. You have to know why you have this legal duty. And I don't think they proved it, but I'll go out on a limb and say, okay, you should just know that if you allow your child to use a gun or have access to a weapon, even when you're there, that you should know you have a duty, a general duty to do what you can to make sure it isn't used against somebody else for your child. Then you have to willfully neglect or refuse to perform that duty. You have to willfully neglect your duty of care. And that failure was grossly negligent to human life. You have to show that she willfully didn't do. She willfully ignored her duty to protect other people, and that she knew by willfully doing it that it was grossly negligent, dangerous to human life. I don't think they came, at least from the closing arguments, because I didn't see all the evidence that was presented. I saw very little of the evidence that the state presented. But in their closing arguments, they didn't tie the facts. She didn't tie the facts of the case into that element of the crime. And then you have to show that the death occurred as a result of that willful negligence to not perform a legal duty, which I don't think they made that argument successfully in the closing argument. And Kelly R with the $5 super chat says, just remember the school saw the pics first. I can't remember it because I didn't know that. The school saw the pics first and did nothing. Well, that's actually very interesting. Thank you so much for that, Kelly. The school, well, why isn't the principal here on trial? Why did they allow the kid to remain in school when he was drawing that picture? Yeah, we know they called the parents. The parents came in, she talked for 11 minutes, et cetera, but they didn't send the child home. What I gathered from the closing arguments was they didn't insist on the child going home. She didn't demand to take the child going home. So they basically said, oh, it's okay if he stays here. If I remember, like from back when this happened, I think there was something about they said that it was okay if the kid remained in school. Why didn't the school use their right to search? You know, yeah, if you're worried about this, if you're concerned enough to call the parents, you should exercise your right to search the lockers, the bag that the principal apparently had in her hand had the gun in it at the time she had it in her hand. Yeah. So I don't think it was a great closing. I don't think she tied in the facts of the case to the elements of the crime. She didn't lay out that roadmap. Like you do that in the opening statements. You lay out the roadmap. Here's what the evidence is going to show. The elements of the crime are this, this, and this, and this, and this is going to prove this, this, and this is going to prove this. And then you have to go back in your closing argument. I say opening statements. In your closing arguments, you have to go back and you have to show them how you led them down this map. You have to show them that, okay, we said we were going to do this. This is what was testified to. This is the evidence that was presented. And for this reason, it establishes this element of the crime. She didn't do that clearly, and she didn't sway me. So I think it's the defense's game to lose at this point, just based purely on my viewing of the prosecution's closing arguments. It's the defense's case to lose. But we know the outcome. We know something happened and the jury came back with a guilty verdict, which right at this point seems to be a few people died, 4 people died, and we're really pissed about this, and we want someone to pay for it. So therefore guilty. That's what it seems like now. Let's fast forward through her bathroom break. And this bathroom break was really weird. Who said I have to go to the bathroom, Your Honor? You just say, may we have a comfort break, or may we have like a 5-minute break? You don't just go like, I gotta pee, like Forrest Gump. But that's the deal there. Let's fast forward here. All right, there she goes. She's gonna go over there. I guess we can just.
You want to do 5 alternates to the jury.
Come in. All right, again, this is an almost 2-hour closing, and at my rate, it's going to take 4 hours to go through this, and that just ain't going to happen. So I'm going to boost it to 1.5. If it's too much, if we can't understand, we'll slow it back down, and I'll get through this until I get tired. We'll get through as much as we can.
Yes, thank you. As the prosecutor finished, she said, "This is shocking, unthinkable." I believe there were other words used throughout trial. Unbelievable, obviously unbelievable, unthinkable, unfathomable. And the reason that's the case is because it was unforeseeable. No one expected this. No one could have expected this, including Mrs. Crumbley.
Okay.
Now, the first thing I want to do very quickly is talk to you about the burden of proof. In the state of Michigan, there are different burden of proofs depending on what kind of a case it is. When people sue for money and say, I've been injured or I was failed by the school even, there will be civil lawsuits and the burden of proof is a preponderance of evidence. That means it's about a 50-50 standard. And if you have 50% of the evidence, that's the burden of proof for civil. When the state thinks it's important to take away a person's children, the burden goes up and the burden has to prove more evidence. And that specifically is clear and convincing evidence that it's correct for the state to be taking away a person's children. Now, the highest burden in this country is in a criminal case, and that is beyond a reasonable doubt. And the reason I'm telling you about the differences in the burdens is because in a criminal case, if you have just one reasonable doubt about the case, you must vote not guilty. And so this is my poster just showing
Good statement.
beyond a reasonable doubt is guilty, but there's many, many other options. If you think it's likely, probable, possible, not likely, those are all not guilties. You have to be sure beyond a reasonable doubt. And later, as I go through my closing, I am going to tell you the reasonable doubts that the defense believes exist in this case for you to look at.
Okay, that's pretty good road mapping. I like it so far.
The other thing I have to ask you to keep in mind is that in the jury instructions, and I think you've been told this throughout trial, the defense does not have to prove or do anything.
Good,
Like Judge
solid
Matthews
argument
said,
there.
we could sit at the table and play chess the whole time, call no witnesses, cross-examine no witnesses, provide no evidence, because we have no burden to prove a thing. However, in this case, you obviously saw the defense present Mrs. Crumbley, who took the stand, so that she could give you some context beyond parts of the evidence that were confusing when the prosecutor was introducing in bits and pieces. And the problem in this case
How is this
that we
dismissive?
all agree
She's
everything
absolutely
can be
correct
seen
so far.
different
How is this
in two
dismissive?
ways. First of all, when you look back in hindsight with 2020 vision, when you look back in hindsight, it is easy to say, this could have been different, that could have been different, this would have changed. And the other circumstance, the second one that makes a huge difference, is when you get full context around the evidence that is being used. And in this case, the prosecutor has cherry-picked little bits of evidence out of mountains of evidence to put in front of you with no context to explain what they're doing. And when you get cherry-picked bits of evidence, it's easy to reach wrong.
I think she missed an opportunity there to say
Now, during jury
hindsight is
selection,
not the
it felt like
standard. The
prosecutor
standard is
was
what
asking
she
you
knew
questions and
at
giving more
that
of a
point in
campaign
time,
speech
not what she
than
knows
a jury
now.
selection proceeding. And I would suggest to you that at the end of the day, the only judge, although Ms. McDonald mentioned she's been a judge and was a judge several times during her jury selection, the only judge in this courtroom that matters is Judge Matthews. And the only other people whose judgment matters are the 12 of you who will collectively decide this case. The rest of us don't matter. My opinion doesn't matter. Ms. McDonald's doesn't matter. The opinions of everyone in this audience doesn't matter. The media and all of the people who think they know everything behind keyboards at home commenting about what they think the evidence in this case has shown. So during this case, it's obvious real life is messy and complicated.
Yes.
And during this trial, I will openly admit that I'm a lawyer who messes up. I get thrown off when I'm surprised by something. I feel like I get overwhelmed when information is coming at me quickly. I say I'm sorry a lot. Evidently, there's a TikTok channel of me saying I'm sorry through this whole trial. And all I'm saying is that I'm human. I am a human being, and so is Mrs. Crumbley. And that's what this case is about. She's not a perfect person or a perfect parent. I'm certainly not a perfect person or a perfect parent. And I'm certainly, beyond a reasonable doubt, bad with technology, which is why you're not going to see me touch that laptop.
What? Okay, wait, that didn't go the way I thought it was going to go. It is really common. Wow, weird. Again, people that didn't know my house is haunted. My my robot vacuum cleaner has apparently been voice triggered, and it's saying something, but I can't hear what it is because they got my earphones on. Something has triggered the voice response. It could just be me yelling. Who knows? But she didn't go where I thought she was going to go with that. It's very, very common in criminal cases, especially where you've kind of got a not so good case. But I mean, I think she's got a good case here. It's very, very common for the lawyers to go, I make mistakes. I'm human. I'm not perfect. If I've said or done anything that upsets you, if I said or did anything that is a mistake, don't hold that against my client. Hold that against me. That's where I thought she was going to go. Don't take my mistakes out on my client. But no, she's like, I'm not perfect and I don't understand technology. Let's move on. That was odd.
So during this trial, I have stood
That was
before
weird.
you and shown you all my flaws, and I embrace them, and they are a part of what makes me human. And so has Jennifer Crumbley. She got on the stand
Weird.
and talked about every nook and cranny of her life, things no one else in the world knew, in her family, among her friends. And she wanted you to see the whole truth, the entire truth, and nothing but the truth
Yeah.
on
Appreciate it.
everything, where she had to show you that she has made immoral decisions to have an affair, that she has made decisions you might not make to have another person involved in the affair. Now, we didn't get too far into the details, but it was enough for you to know that Mrs. Crumbley got up there and literally stripped
I'm
off her
only
armor, let the
human.
prosecution
Born
cross-examine
to
her and
make
show you what
mistakes.
happened in her messy life. And I say that with all kindness because I'm a mess too.
Why?
I saw a meme about a week ago that said, I'm trying to be a mom, trying to get exercised, stay hydrated, get enough sleep, text everyone back, and not lose my shit. And I've got to be honest, as a mom, a working mom, on most days, I'm lucky if I'm fit for human contact. I'm lucky if I've taken a true shower and didn't just grab a handful
What?
of wipes and scrub off the best I can on my way
What
running
the
out the door,
fuck?
putting on my makeup as I drive to court in my car.
What
Because
is
my life
this?
is not perfect, and no one's is.
Why is she
And during
saying
this
that she
trial,
doesn't
You
shower?
may have concluded that you don't like me,
What?
that you hate me. That's fine. I am just asking that your opinions about me as a person, and if you're one of the people who plans to make a TikTok about me, that you won't hold those opinions against Jennifer.
Oh my
Crumbley and
God.
will
This whole thing was leading up to that. Oh my God. That is literally a 2 or 3 sentence statement. What the hell did I just watch? That was dumb. That was a waste. That was stupid. Now we've got the jury going, huh? But you don't, you're very lucky if you just wipe yourself off with wet wipes on the way to the office. Oh, and you put on your makeup while you drive. So sort of drive all, that's a weird ass thing to say. Duncan Idaho dropping another $5 super chat. Thank you very much, brother. Telling the jury your defendant embraces all her flaws, which may have contributed to the shooting to any degree, is not a great strategy. Yeah. I would agree. This has been okay. This is weird. This is weird. I know she's trying to draw a parallel, but it's like the parallel you don't want to draw. Ew.
judge Jennifer Crumbley's case based on the evidence about her and her family. And if you hate her or don't like her or agree with things she's done, that's okay too. You don't have to like her. You are not expected to go hang out with her when this is all over. After trial, you don't have to decide if you want to go to her house. You don't have to have Thanksgiving with her. But when you're looking at the evidence in this case, it's important to set aside your opinions of her or take your opinions of me.
This is a one sentence thing. We have to make sure we separate opinion from facts. This is not a feelings deal. It's a factual thing. It's a matter of law.
I am Jennifer Crumbley, and I could be here accused and sitting in her spot very easily. Now, in my house, we don't have guns. I don't have guns, but I do have children. And actually, I have an oopsie baby, my 4th one.
Oh my God!
For in 4 years.
What the fuck? What is she doing? This is okay, guys. Now we're like 3 minutes into this, and I know why you wanted me to watch this now. This is weird. She's continuing to draw these really weird parallels that you probably don't want to be drawing. I have an oopsie baby too. I just don't tell him he's stupid. Like my defense. What? Oh my God. Duncan Idaho again. Defense. Sometimes I don't even wipe. I smell bad. This is the Ralph Wiggum. We've had the Chewbacca defense. From South. This is the Ralph Wiggum defense. I don't wipe. I smell funny. Island of the $2. Embrace the strange journey, Jeff. Don't fight it. Yeah, I'm doing that. And Amber Morris with a $5 super chat. Thank you so much. Shannon had tech props, got flustered, and then said, I'm going to kill myself in front of the jury. Oh, no. I'm not surprised. Oh, no. That's less than ideal, isn't it? That's not something you want your lawyer to be saying. It's sort of like the YNW Melly trial where the defense counsel Raven Liberty was holding up the book in front of the jury, covering her client who is on trial for 2 murders, holding up this memo book that says evil plans and stuff on it. Yeah, don't do that. Warrior be out to the $5 super chat. So if I find my kid as a threat, do I have a right for state-sanctioned unaliving of said child? No. State wants to have it both ways, and no matter what, you fuck. Yeah. This is just this so far is bad shit happened. We're angry, and we want someone to pay. We want a lot of people. We want everybody to pay. That's not good law.
But that's what I was blessed with. I say I'm abundantly blessed. And I have kids that seem to have no issues. And at the end of the day, they're good kids. They go to school. We have no discipline problems. We have arguments here and there, just like every family does.
This ain't about you. Why does she keep talking about herself?
Me very rarely, but I have no belief that any of my 4 children would ever harm anyone else. And while I don't have a gun, I have a large butcher block on my counter with big knives that I use when I cook, and I enjoy cooking. And at the end of the day, my kids could just as easily grab a knife without me knowing it and without me having it on my radar and walk out the door of my house and go play with their kids, the other kids on my block. Granted, they live farther down my block because I'm in the middle of nowhere. And my son could kill somebody with my butcher block knife that I would have never expected to happen.
No,
And
don't
if
make this
you
about
saw
you.
text
Make it about a
messages that my
generic
husband and I
person.
exchanged
A
on our
person.
throughout this
Anybody
year,
could take a
and
knife from their
it
house.
would be
And the
so
parent.
easy for me to be in her seat.
Apparently, the jury doesn't like
With my
either of
kids, I
you.
don't
Why
know
are you
their
saying
assignments.
this?
I don't look at their phones. I have no reason to. My son plays a lot of video games. My son's online talking to a bunch of people as he's playing a lot of video games. Even though he has a cell phone, I don't go through it and look at his messages every day. And as he gets older, I do know he's interested in girls. If he starts receiving nude pictures of a girl on the cell phone I own but let him use and gave him for his birthday when he turned 11, should I be held accountable for receiving child pornography?
Oh, no,
and
don't
sex
say- oh,
some
my-
over some inappropriate pictures? If my son decides he's going to send some pictures back and takes a new picture of his bits and pieces, that's a 20-year felony. Am I then responsible?
Oh my God, the jury clearly doesn't like anybody here. Why is she saying this? Now they're going, yeah, you should. Yeah, you should, you degenerate defense lawyer. Yeah, your kid should go down if he does this. Just the same way she's going to go down for this. Oh no. Oh no, don't personalize this. Just make it the generic person. Anybody. We all have knives in our kitchen, and personalize it for the jury, not yourself, dumbass. Say any one of you in the jury, you have knives in your kitchen. Any one of your children could take a knife and something could happen, or they could give a knife to a friend and something happens. Do you want to be held liable for it? We live in the day of sexting. Your child gets an unsolicited or unwanted text message from someone. Your child. Should you as a parent be held liable and forced to be on a register somewhere? Should you serve time because someone sent this to your child? If your child does something stupid and sends a picture of his or her junk to somebody, should you go to jail? Personalize it for the jury, not me as your lawyer, because oh my God, this is weird. All right.
Because he sent a picture of his penis over to some girl.
Well, don't say penis.
So not only taking the picture, a 20-year felony, but then we've got a 7-year felony for sending it over. Can every parent really be responsible for everything their children do? Especially when it's not foreseeable. And this clearly was not foreseeable to Mrs. Crumbley, because there's no one in the world, including Mrs. Crumbley, who would have let a school shooting happen and let what happened on November 30th take place. Not only ruining the lives of so many families and victims and taking the lives of 4 young people, but also ruining her own son's life and ripping his life right from her as well. She would be the first person on the planet who would have never let that happen in a million years. So this case is a very dangerous one for parents out there. It just is. And it is.
Yes, it is.
Of its kind. Luckily, however, this is a case where the prosecution cannot meet its burden of proof. And thankfully, it's a case where truly Mrs. Crumbley does have a defense. And this isn't just one of those stretched cases where a parent is liable for what their child has done. Now, the judge is going to tell you that you have to, if you find reasonable doubt in this case, you must find the defendant not guilty. And the law says you must have a reasonable doubt, not 3 reasonable doubts, not 5 reasonable doubts, not 10. If you have a single reasonable doubt, you must vote not guilty for Mrs. Crumbley. And when it comes to reasonable doubt, each of you can have a separate reason to have doubt in this case. You don't have to agree on what the doubt is. And for that reason, what I am going to do is show you all of the doubts that the defense believes exist in this matter.
Okay, do it.
Some of them may speak to one juror, some of them may speak to another, but at the end of the day, if you have just one, your vote in this case must be not guilty. So the first place the defense finds reasonable doubt is in the fact that the prosecution is so desperate to prosecute this case that they admitted a mountain of evidence that, quite frankly, was unnecessary. Now, they say to you, they needed to show you, they needed to prove the manner of death. We stipulated that 4 people died. We stipulated that it was the most horrific set of facts you could ever imagine.
Okay, reasonable
We
doubt
stipulated that what
because you
happened
put
to
in
Molly
extra
Bell and
evidence
Christy
isn't the
Gibson
thing.
Marshall was horrible. But this prosecution, putting that evidence on, was designed to inflame you and make you emotional, strike your sympathy, and get you to hate Mrs. Crumbley, which, by the way, has been very effective for most of the media, most of the public, and for anyone who has seen information put out by this prosecutor in this case. A second reasonable doubt comes from the fact that we know, and the evidence in this case showed, context is key. And that was clear when Detective Wygrowski took the stand and said, you get better decisions when you have more evidence, and testified that in a former hearing, he messed up because he didn't have the video from before the one he saw. So he believed the parents arrived at the school together. And subsequently, when given more context, showing more video from further beforehand, he could see they actually arrived in different cars, met, and walked in the building together. And at the end of the day, the more context you have, the more accurate you can be. When Brian Maloche testified, another example came about where the prosecution had him testify that Mrs. Crumbley decided to delete his messages, clear your cache. And I'm so thankful that
Cache? You really don't know technology, do you?
And
Okay, there you go.
When Brian ended up seeing the messages before.
Wait, she just said clear your cache. I didn't know how to pronounce cache. Now I do. Cache. Not cache, cache.
Cache, because now I do. And when Brian ended up seeing the messages before clear your cache and after clear your cache, he realized.
Is there anybody outside of France or Eastern Canada that actually says cache? Look, I come from Cache Valley, C-A-C-H-E Valley, Cache Valley, Utah, where trappers back in the day, Jim Bridger, and Lewis and Clark and whatnot, people that go through that area, they would store caches of furs like beaver pelts and bear furs and elk and all sorts of other animals. They would cache the furs there for the winter and take them places. Cache, not cache. It's Cache. I come from Cache Valley. I know whereof I speak.
Oh, she wasn't asking me to delete messages. She wanted me to refresh my web browser to see if the Facebook had actually deactivated. And so that was proof again that when you have more context, you're more accurate. And the problem the prosecutors in this case is they have very little context for the very little evidence they submitted. There's also no context around some of this little bits and pieces of useless evidence, like Jennifer Crumbley saying that her son was an oopsie baby. I call my son that, so what? Does that mean I hate my son? Does
God.
I would be okay if he went and killed a bunch of people and or if he committed suicide? No. Calling your child an oopsie baby was designed to try to make her look bad with no context. Having Amanda Holland come in, a coworker who's not a friend to Jennifer Crumbley and has been interviewed by law enforcement to tell you her advice on she should go have a mother Sunday with her teenager, so irrelevant when she's faced with raising toddlers every day. When I heard her advice, I thought, yeah, right. I have 3 teenagers. I almost have a 4th. And personally, not only would they rather do anything else than spend a day with me, I'd rather do anything else. And we do.
So you don't shower.
That's their first priority when they get to pick.
Your children hate you. You're doing a great job here of convincing them of your client's innocence.
It does not mean she loved her son any less. If she ever told a witness, my son is weird. And part of what made me realize I could be in Mrs. Crumbley's shoes is I sent text to my husband saying, our daughter is a psycho today. On the way to school last week, she's crying. She doesn't have people to sit with at lunch. I texted him, she's a nutcase. I don't know what to do. I don't know how to handle this. I don't have time for this. My other daughter is complaining about her lights flickering in her room. I texted my husband, this sounds like a case. the start of a case. My husband works for my office. He's actually my office manager, so he knows about the case. He went in a room and figured out in 5 minutes, it's because when she flips her blow dryer on, one of our plugs makes the lights flicker. So this ghost that you would read about in my text messages, which by the way, I didn't.
What the fuck is going on here? Is she on trial? Is she the defendant? Why is she giving us her life story? This is weird. This is just all weird and unnecessary. I don't understand.
Not respond to, despite the fact that it's on our 6-person group chat.
I was just saying, is this a closing or therapy? I was just going to say that, Sasha.
I don't really care that my daughter is crazy. I also got text one day. We have no food in our house. I am absolutely starving. You are the worst mother ever. And you know what I did? I ignored it. She was mad we didn't have the right kind of chicken ramen when we have 85. I like the number 85. When we have 4 other flavors of ramen and there's about 100 other things she can eat. And I knew she's not going to starve to death, but taken out of context, it makes me look like a neglectful mother. But if you know all the circumstances and you know the relationship I have with my daughter, I knew it was an overdramatic, stupid point. So when you see messages from Mrs. Crumbley's son saying, will you at least call back? Those are so out of context. And when I'm driving home from court every day, I'm getting messages, will you at least call back? And I don't, because I know what they want is for me to run through the McDonald's.
Don't do that, D. What? It's illegal.
I do stop and get myself a Coke, but I am not getting a round of drinks every day for everyone. And I've realized it's easier to not answer the phone.
What the God is she talking about?
You can find reasonable doubt from the context that the defense did actually provide. And when
How is anything she just said evidence of reasonable doubt? She would have been better off not saying any of that. Like literally not saying any of that would have been infinitely better than saying any of that. What the hell does that have to do with providing reasonable doubt?
Mrs. Crumbley got on the stand and explained to you her understanding of ghosts and dishes flying and laundry flying, that is evidence. And that is something that can create reasonable doubt to hear what was really going on. Even if you believe the prosecution's dates about what was going on, it's not strong evidence. It's very misleading. And I'm going to go through what it does show. There are 3 sets of dates involving Mrs. Crumbley, all from March of 2021. The first time is March 8th and 9th. They introduced exhibits, including text.
Oh no, she's effective. She's just not very good. It's not even close to ineffective assistance of counsel.
Then they introduced evidence on March 9th that she went to the barn that day with her husband on the 9th. Then they introduced evidence, and I will give them credit. They put together quite a case, although it's really not important, that there was a picture of the horse taken at the barn that day, that the data supports there was a picture of the horse taken at the barn that day, and that there was GPS tracking information supporting that she was at the barn that day. Okay, fine. So on March 8th and 9th, there's concern that the shooter, Mrs. Crumbley's son, is making weird comments, and on the 9th, she goes to the barn and she takes some horse pictures. That's all that shows. Pretty minimal. Next, they went to March 16th through 19th, which was broken up into a million exhibits that, quite frankly, were out of order, threw me off my game, helped create these beautiful TikToks. And I'm going to tell you what they show. Now, these ended up all being admitted as exhibits, but I'm going to go in order of what they show. There was a text thread in Exhibit 85, which if you want to look at it, you can, where Jennifer Crumbley said, I'm going to get drunk and ride my horse. This was on March 17th, St. Patrick's Day. A lot of people
Happy St. Patrick's Day.
That does not make her a mother that would be negligent or grossly negligent to her child.
And fun fact, in more than half of the states in the United States, it is illegal to ride a horse while drunk. You can be charged with DUI for riding horseback drunk in slightly over half of the states. Michigan, along with Utah, is a state where you cannot be convicted of a DUI for riding a horse while drunk. So there's nothing wrong with her having a few drinks and riding a horse.
There's text messages from the day before where Mrs. Crumbley's son is saying some things about, now the house is haunted. Some weird shit just happened. Now I'm scared. I got some videos, a picture of a demon. It's throwing bowls. I'm not joking. It fucked up the kitchen. I'm going outside for a while.
Good kid.
Can you at least text back? On that day, Mrs. Crumbley didn't text back, but their own exhibit, okay, which is Exhibit 83, so the numbers do bounce around. So we go from 85 to 86 to 83.
Doesn't matter.
That within an hour of the shooter making these ghost comments, she did call him. Specifically, she called him back at 7:24, and they had a 19-second phone call. If it was 19 seconds, it most likely was, I'm on my way home, we'll talk when I get home.
Okay, that was a little bit of facts, not an
an
evidence, I guess.
Some proof here.
A little speculation there.
Exhibits 87, which show on the 17th on St. Patrick's Day, James was on a horse. They showed People's Exhibit 88, confirming the metadata that James was on a horse. They showed a picture, 89, of Jennifer on a horse that day. Metadata to prove she's on a horse that day. Another picture, number 91, of James on the horse, a different picture. The metadata to prove James is on the horse.
Okay, I like this part.
A picture of Jennifer with her horse in Exhibit 93. And then the metadata to support the picture was taken out of the barn.
I actually like this part.
That these people talked about these horses. It's all fine. That's on the 17th of March. You're going to have access to all this evidence if you want to see it.
Okay, I like that.
Then we introduced exhibit
It's
number
proven that they were on a
86,
horse on March
which is
17th.
where their son says the house is haunted. This is on the 17th. This is the day where he says, can you text back? This is the day where I already showed you the exhibit. She called him. She didn't text back, but she called him. And then they show a couple texts from a few days later on the 19th, where it's obvious from the messages, the Crumbleys had an argument with their son the night before. He was upset to have his phone and things taken away. That Jennifer Crumbley gave him a melatonin to go to sleep. She should have only given him a half. It's in the messages, but she gave him the whole thing. And it knocked him out and he slept in their bed that night. And when he woke up the next morning, James described him in the text messages as he woke up looking like he had way too much to drink last night, complaining about a headache. Jennifer says, well, he was really worked up and out of control, so I can see why, talking about his behavior during the fight. All I know, Jennifer says, he needs to eat, go to work hard, not complain, and he can get his stuff back. She testified that getting his stuff taken away is his trigger. It's what makes him get upset. She says, you respond, and I didn't get it. James says, Jesus, yes. He said, let me ask you a question. Why am I in your room? That's when they talk about the melatonin. She says, oh my God. James says, I really thought you were giving him a Xanax last night. Jennifer says, does he seem better? No, melatonin. James says, I know. So obviously he's joking. Jennifer writes, but he hasn't had one before, so I should have only given him a half. James writes, well, he's doing his school, says his head's hurt, so he took Tylenol. Jennifer
This all
asks,
seems
"Is he making
reasonable."
work?" James says, yeah. Does he remember what he did? James finally says, dude, I'm working. I'm on a demo right now. I haven't talked to him. He's doing school. And that's really the extent of the conversation. So fine. So one day they get in an argument. And I'll tell you what, those kind of arguments, in a heartbeat could have me sitting in her chair.
I think we're only 1.5.
The state
This is only
claims
1.5
had
speed, not
knowledge about back
2.0.
from March of 2021.
1.5.
Are exhibits 96 through 100. And 96 starts off with their son saying, I'm picking up the room. I cleaned until the clothes started flying off the wall. This stuff only happens when I'm home alone. I pick the clothes back up though. And that's the important part of those texts on the 20th. We know on that date, because the people proved it, no pun intended, but they beat a dead horse, that at 97, it's a picture of Jennifer at the barn. We've got the metadata showing Jennifer was at the barn. We've got another picture on 99 showing Jennifer was at the barn. And exhibit 100, Jennifer was at the barn. Big deal. Jennifer's at the barn. Their son is saying goofy stuff. Jennifer gave you the context. They had an Ouija board for a couple months. After Christmas of 2020, he and his friend are playing with the Ouija board. They ultimately lost interest. They stopped doing it. Jennifer admitted to you one day to mess with them. She turned the power off in the house, turned the circuit off to mess with them. She mentioned a time where James pretended he was getting electrocuted. She didn't know what to do. She's screaming, trying to kick him, see if he's electrocuted. Ethan is laughing, taking a video of the whole thing. This family played together. They had fun. They did what families do. The prosecution just had zero context because they had tunnel vision that she was doing something wrong.
Okay, I like this. She's doing actually a good job here. She's doing good.
Convincing you that was
I
the
like
case. So the other thing that you can find as a reasonable doubt in the case is the lack of evidence in the case as a whole. The prosecution has made very serious claims. And when you really look at it, they have very little evidence. So what they've shown to you, and I have it in these folders, are these dates in March 2021, which, by the way, are 10 months before the shooting even took place. They're before it would have, it's unreasonable to expect that things that happened in March of 2021 are an indicator that 10 months later their son's going to do something. It would be very different if every week there's something going on up until the shooting, but there's not.
Yeah, I was going to mention that. They had this mental health crisis and there was all this stuff going on. And that was in March. when this happened, what, in November? So I was going to mention that maybe he was perfectly fine, perfectly clean. Maybe it sorted himself out in the intervening time. I was going to mention that.
Because if there was, the prosecution would have brought that in and showed you every horrible thing that was happening to show you their son was being ignored, and they don't have the evidence. So what they did provide and what was admitted, this is exhibit, I believe, 423. These are all the Facebook messages between James and Jennifer. So when
Good
you look
God.
at those Facebook messages and consider, and this includes the photographs and the GPS stuff, that they're using this much compared to this much over the period between January 2021 and the shooting. This is a very little bits in time compared to the grand scheme of things. And while the officer testified and played games with me that he's not sure this is the best evidence against mother, you better believe if they had better evidence, they'd be up here showing stronger and better evidence. This is it, ladies and gentlemen.
Okay, real quickly, we have an interesting thing here. We have a difference of opinion. We have where to go. Paralegal Liz, and she's explaining to them like she's getting onto them. Lol, I don't like the delivery, and Island's agreeing here. Island's saying, yeah, she talks at them like it's stupid she has to be here, and they both don't like it. I like this. I really like this delivery. It's like, look, they're trying to tell you that they have all of this stuff. All they've done is they've proven that they were on a horse on 2 separate occasions. They've left out information. I like that she's saying, look, they have shown so little. They're wasting our time being here. They don't have a case. They've wasted our time. They've wasted my time. They've wasted your time. They haven't proved any elements of the crime, but they have proven that they go to the barn every now and then. I like this delivery. That's my opinion. I like this
from the
delivery.
evidence in trial, and you may find it to be a reasonable doubt, that the Crumbley son was a skilled manipulator and they didn't realize it. He's not sick. He doesn't have a mental illness. He's had no history of hallucinations. He has never shown his parents signs of mental illness. He certainly never showed signs of mental illness wanting to get a gun. No parent would purchase a weapon if they believed their child had mental illnesses. And these are people that had 2 other guns in the house for months where nothing ever happened with those guns. They had no reason to believe that somehow this 3rd gun was the thing that was going to make the difference.
Yeah.
The texts that the prosecution admitted as exhibit 101 were texts between the shooter and his friend that we have not named. The extent of these text messages saying goofy things like, I told my dad to take me to the doctor, he gave me pills to suck it up. It's at the point I'm asking to go to the doctor. I'm having insomnia and paranoia. I'm calling 911. I thought about calling 911, but my parents will be pissed. I don't disagree with the prosecution that these are alarming messages, but clearly the shooter's friend isn't that alarmed because he's not texting back. The shooter's friend knows there must be more going on because he doesn't tell Mrs. Crumbley, who is like,
Yes, he did. Did the parents know about those texts?
We have no other context about these messages, and if anything, the evidence does not show that Mrs. Crumbley ever saw these messages.
There you go,
Now, when
right
she
there.
sees them now, she thinks that's crazy.
There's
She
reasonable
likes
doubt
more
right there.
context. But you also have to know, and another reasonable doubt you may find in this case is created when you compare these text messages that were sent that have alarming things between Ethan and his friend to all of the messages between them, which are over 20,000. And what you
Oh my
have to
God.
believe, and what I would believe is that if the state had stronger evidence, they would have paraded it up and we would have been seeing a lot more of these. But instead, they were admitted, and you haven't heard the friend testify, you haven't heard any context about these, and all you can see, and really all the evidence shows, is that there's no reason to believe Mrs. Crumbley ever saw that.
So, there you go.
I don't want to have
So,
another leaning tower of Pisa situation. Let's move this down.
I'm watching.
I've taken your advice. Now, the other evidence the state has shown are little bits and pieces from the shooter's journal that are quite alarming and disturbing. But again, Mrs. Crumbley says the information in there about my parents won't listen to me for help is not true. And there is no evidence to show she ever saw that 22-page handwritten document. She never saw the little bits of evidence that the prosecution admitted. To evaluate this case, you have to look at it from the perspective of what she knew. So the journal information and the small amount of
I don't like the
text
flashcards.
with his friend are things she didn't know about. There's also 2 times where the state says that they have proof that Mrs. Crumbley's son was showing signs of depression or being sad or lonely. All right, those come from April 29th, 2001. This is when Jennifer Crumbley emails the friend, his mother, and all she says is that her son has been acting kind of depressed. She doesn't know what's going on. She's trying to find out what's going on, but he won't really tell her much. She's trying to find out if there's an issue between the two boys she should be aware of. She's trying to get down to the bottom of it. If anything, she's doing what a good mom does to try to figure it out. But the worst of what she says is that he's stressed by school. I don't want to get this wrong. He's been acting kind of depressed.
Kind of.
And
I'll be right
There's
back.
not an issue between them. Then they go on to make plans for their son. This was admitted as Exhibit 104. If you put my text up there and showed every time I told my mom that one of my kids was acting depressed or weird, I guess my favorite word is moody these days, it would look like my kids were complete lunatics. I'm actually shocked Jennifer Crumbley doesn't have more texts about her son acting like a typical teenager. And Jennifer Crumbley testified that although she said that, she didn't think it was anything she needed to run to a doctor about or anything she needed to do anything more with. And this moment passed, because if it didn't, the prosecution would have brought in all the texts that went beyond this, and there'd be more evidence. They also run in text with the same parent of the friend from Exhibit 105, the friend's mother, when Jennifer Crumbley reaches out to her saying she had no clue what they were going through with their son, and she felt really bad about it, and asked how they're all doing, and that they're thinking about them, that family, a lot. And ultimately, the worst that Jennifer Crumbley says about her son is, I know my son misses him. And if you need anything at all, don't hesitate to ask. That's it. It doesn't go on with wild depressions or hallucinations or mental health issues. That's it. That's it. I'm actually shocked there's not more instances of depression or moodiness where my kid is acting weird. The fact that there's this little evidence is shocking to me. However, it's a lack of evidence on the state's part. There's also a lack of evidence in Mrs. Crumbley saying he's depressed to really anyone else. Even after the shooting, when
Oh, wow.
she testified,
Apparently I didn't miss anything.
to her friend Kira, to other people, to Brian, all she keeps saying over and over is, I wish there had been signs. I wish there had been something. He's a normal kid. There's a complete lack of evidence of mental health concerns specifically. If
Okay.
you want to really spend some time digging into this, you can read all the messages between James and Jennifer Crumbley, all of them, and you will find that there are not texts that go on and on that their son was exhibiting anything close to a mental health concern. And again, my text would read worse because I say things like, I think my daughter's psychotic.
Don't go back to you.
When Mrs. Crumbley did have to evaluate what's going on with her son, and there was something alarming happening, she relied on people who spend day in and day out with kids, people she considers to have more expertise in kids than she does, including Pam Fine, who left her a very nonchalant voicemail that you've heard. It was Exhibit 115, if you want to hear it again, saying Ethan was looking up bullets in school today. It's not illegal. It's not wrong. He's not in any trouble. It's just like how teachers can't look up hops for beer. You don't need to call me back.
Huh?
She was relying on the representations by the school counselor, Sean Hopkins, who took the stand and has had a lot of training, hundreds of hours of training, and made it very clear this was just an issue where he needed some kind of therapy and didn't think it was necessary to suggest to the Crumbleys, go to Common Ground today, or serious enough that he called 911. And she relied on the assistant dean, who also has an abundance of experience Mrs. Crumbley doesn't have. And quite frankly, my kids didn't come with a handbook, and my guess is her son didn't either. And the assistant
Oh,
dean
nice.
said the
Nice
same
prosecutor. Your phone
thing in
went
the meeting
off.
with Mr. Hopkins,
Dipshit.
that Ethan Crumbley that the son could remain in school that day, that he would probably be better off, according to Mr. Hopkins, around peers versus being alone. And that as long as they got him an appointment within 48 hours for some kind of counseling or therapist, that was sufficient. So it's absolutely not credible when a witness from the school, like Mr. Hopkins or Mr. Ejak, gets up on the stand and says, even if a kid is very sick, we cannot force them to go home. That is not true. And as parents with common sense, you should know that's not true. Because when my kids are puking, my kid's school will not let them be there. And when they have a temperature, not only can they not be there, but my children's school is always nice enough to remind me they can't be there for the next 24 hours, which means they can't be there the next day either. So reasonable doubt can be found in the fact that trained professionals told Mrs. Crumbley her son was not a risk, and Mrs. Crumbley relied upon it. This school also failed to even really look at the situation and tell her about things from the year before. They made it very clear that he was not in any kind of discipline issue, which is shocking to me and was shocking to Mrs. Crumbley, considering he's off topic looking at bullets in school. He's looking at a video in school of some kind of violent pictures. And then he draws a gun on his math paper instead of doing the math paper. So
Instead of
when
doing the
school
gun.
officials say,
Oh.
okay, this is really not a big deal. All we want is a counselor within 48 hours. Mrs. Crumbley took that as a very strong sign that things were fine.
That sounds
And
reasonable to
doubt can come
me.
from the fact that those 3 people at the school, Fine, EJAC, and Hopkins, are mandatory reporters by CPS who would have reported if they thought Mrs. Crumbley or Mr. Crumbley were neglecting their son.
That
Mrs.
sounds
Crumbley even
perfectly reasonable to
commented
me.
to others about the nonchalance that was at that meeting, that it was only 12 minutes long, which surprised her, that she was disappointed they didn't take it more seriously, that she was surprised there was no disciplinary action, and she left the school actually feeling better that maybe she had overreacted when she flew over to the school. Now, the people who are trained in these areas, they didn't just say, we're not trained in these areas. They gave specific examples. They said that kids who are really a threat, they would show nervous behavior. They would show anxiety about somebody else handling their belongings. In this case, the shooter was cool as a cucumber as Mr. EJAC went down, got his backpack with the gun in it, and brought it to him. And Mr. Hopkins and EJAC said they hoped they could get him into counseling today, but ultimately said he can stay at school and we'll give you 24 hours or 48 hours to get it situated.
Okay, the school allowed him to remain. Why should the mother pull him out? Why should the mother?
Mrs. Crumbley knew they had got a gun and that the people at the school didn't. This is Oxford Community Schools. These professionals testified about how common guns are at the school, so common, and this kind of blew me away, although I live out there, that students are known to go to the gun ranges often, that girls on homecoming wearing their short little party dresses they wear to the dance take photos before the dance holding their guns, that kids go hunting on Late Start Wednesday before they go to school, and the school has to give reminders to parents for people to leave their guns at home.
Okay, now we're in familiar territory. I know it's prevalent in Utah, Idaho, Wyoming, Colorado. I don't know. I don't know if it still is anywhere. But back in the day when I was a kid, deer hunting would start at, I believe it was 8 a.m. or when the sun first comes up over the mountain on a Saturday morning in October, usually right around the second weekend of October. Everybody would leave school on Friday. Like on Friday before deer hunting, the school was a ghost town. It was there was like nobody there. There was a handful of students remaining at the school the day before deer hunting season started. And so eventually it got to the point where deer hunting Friday was half a day. You went to lunch, you had lunch, you got on school bus and went home on Friday, the day before deer hunting, because nobody would come to school in the afternoon of deer hunting day.
So this school that obviously has a strong gun culture going on, that sees a student looking at bullets, looking at a video game type thing with violence, and seeing a gun drawn on a paper, that these school officials, knowing that community, that they didn't ask if he had a gun when they carried the backpack down and did make a comment about how heavy it was.
I actually heard about this group like a week and a half
and I
ago.
misunderstood and thought it had been made to the shooter.
So weird, yeah. Like
So
I just heard
Mr.
about
and
them.
Mrs. Crumbley, they didn't mention the gun, but they did mention that they had been at the shooting range with their son. And this is a community that is so into guns. I can't even believe that these girls, I always look at those pictures on Facebook and think, oh my God, how short are those dresses? And these are girls showing their dresses with their guns in their hand. They know this is a gun community. Reasonable doubt can be found from the fact that the biggest concern at the time was suicide and not homicide. The worst case scenario that was presented would lead a reasonable person to believe there was a possibility of suicide, not homicide.
All right, fair enough. She's making great arguments.
The prosecution seemed to also carry on about the amount of money and time that Mrs. Crumbley spent on horses. Just because she spends money and time on horses doesn't mean she doesn't love her son.
That was my question at the
And
beginning. What does
that
how
we
much
have to
money she
stretch
spends
so
on
much
horses
to
have
create
to do with
reasonable doubt. And
anything?
if you actually look at the exhibits the defense submitted, you'll see that Mrs. Crumbley said she has to get a second job to pay for the braces, which are very expensive to put on her child's teeth. She paid for her son to be a part of a bowling team. She paid for him to do other sports. She cared about her son. Just because she cared about horses and bought medication from them and had a horse hobby, that's not any different than a dad who likes golf and buys new golf clubs and has a membership to a country club and spends time there and spends money at the bar there on days they go golfing. It's not any different. To try to suggest that it shows the priorities were on horses and not their son is just garbage. This is a son who had everything he needed and all kinds of opportunities in life. A son they take camping and on vacation to Cedar Point. Not only do they take him, they take a friend with them. These are parents that clearly love their child. They're sitting there playing board games with him, spending time doing that. That's all in the Facebook pictures that were admitted. Those are submitted to you as exhibits, and you can take a look at them if you want to. Brian's testimony in this case absolutely creates reasonable doubt. When Brian Meloche testified, there's no question he was inconsistent. And I would submit to you that after, there was no reason law enforcement needed to interview him for 2 hours, 1 hour, and then 3 hours. But over time, the police certainly caught on to the fact that the more you ask Brian the same question over and over, and he realizes he's not getting the answer you like, he changes it. And while the prosecution tries to make it sound like, well, he didn't want his affair outed, from the very beginning, he told them he was having the affair with Mrs. Crumbley. That was not something that ever changed. It wasn't until the third interview when they started talking about his pension, talking about his job, that he felt pressure. He agreed with the word pressure, and he agreed with the word veiled threats, although he did take it back later, that the police wanted him to say something bad about Mrs. Crumbley. And I would submit to you that they probably did that to all of the witnesses in the case. But Brian Meloche was the one who admitted to it. And when Mr. Keast got back up there and asked him more questions and asked him more questions, Brian got right back in line like he was supposed to and told them exactly what he knew they wanted to hear. Brian is a terrible witness. He said he had memory problems. And quite frankly, when he's testifying that he knows that the gun was in the car that day of the shooting, we all know no one thinks that's true. Mrs. Crumbley testified and explained the day the gun was in the car. Brian's just wrong. And when Brian testified that Brady was gone and he believed Brady died or committed suicide, I would submit to the jury that Brian is just an idiot and has no clue. And that the truth is, he didn't know the details about where the shooter's friend went.
I don't know the details of that, but I love that. I submit to the jury that Brian's just an idiot. Okay, I like her now. As long as she's not talking about herself, I like her. This whole weird parallels to your own life is weird, and don't ever do it again. It's dumb. But I like her arguments. I like her delivery style when she's not talking about herself. That was brilliant. I submit to the jury that Brian is just an idiot.
He just knew he went away. Wherever he got that suicide idea from, who knows? The prosecution didn't show any texts or anything to support that. But it's clear that Brian Meloche has been put on a mission, which is you're coming into court, you've got some things hanging over your head, and we want you to take a position against Mrs. Crumbley. And I would submit to you that if you read the 77-page exhibit that I got yesterday and went through in painstaking detail with you, you can see that Brian Meloche did not think of Mrs. Crumbley that way when he knew her and when he dealt with her. And he testified the only places he got new information about her that made him think differently about his answers were from law enforcement and were from the media. The media that we have talked about in this case repeatedly as being inaccurate. Brian admitted that when the prosecution asked him, and we've already talked about this, to delete his messages, when I went through the part about clear the cache, Jennifer telling him clear the cache, showed him the stuff before and after, he realized it was just to refresh the page to see if Facebook had deactivated. So giving him little bits of information is particularly dangerous because he's not the sharpest. And that's what the prosecution did. They used him to their advantage to try to make it sound like they have this case and all these horrible statements against Mrs. Crumbley. And by the way, when they presented evidence that Mrs. Crumbley is deleting texts and keep making it sound like she selects different texts here and there, it actually sounds like Mrs. Crumbley deletes all her texts, as she testified, that when people start flooding her with text, she deletes entire threads at a time. Who knows what she's deleting? We saw her on her phone flipping through them super fast. And the texts ultimately that she deleted, the prosecution did point out 2 of them in their closing. They pointed out the texts about we're fucked and we're on the run again, but they didn't mention that she deleted 2 texts that are actually very exculpatory and helpful to her. Why would she delete some of the most helpful and exculpatory things she said? Those 2 texts are on page 42 and 44 if you want to see them in the 77-page exhibit. And those 2 texts confirm, she calls it the string lock was on the gun. She means the cable lock, but she doesn't know enough about guns to say cable lock. The string lock was on the gun.
String lock.
The text that the prosecution didn't mention was when she said that the weapon had been locked, the ammunition had been stored separately, and that everything was not loaded. There's no reason she would delete 2 messages that are that helpful to her. She's just a person who deletes all of her messages, as she testified to. You can find reasonable doubt that Mrs. Crumbley's state of mind is very obvious in statements she made after the shooting. Right away, she's talking about how she had no signs to believe anything would happen. At the substation interview, it's on recording, we watched it. She tells the interviewer, I had no signs. There were no signs. Then when they have her in the car, the squad car, and she's in the back, she says to them again, I had no signs. In her text message with Kira, which was admitted, she says there were no signs. Kira says there probably were, you just missed them. With Brian Maloche, Mrs. Crumbley says again, there were no signs. I would submit to you, this is not some master plan where Mrs. Crumbley decides she's going to suddenly say there's no signs. First of all, there's no evidence of signs.
Yeah, me too, Alabama.
And second,
Me too, Rose. I'm with you.
Fast statements in a time of stress, when right after she's had guns held to her face, walking out the front door of her house, she's saying there were no signs. You might find, and I know the prosecution takes issue with this one, but Mrs. Crumbley was actually, in fact, a hypervigilant mother. She's the kind of mother who is going to the friend's mom to chase down why he's having a moody and kind of depressed day. She's on Power Schools on the app multiple times a day, checking for missing assignments. She's emailing teachers about grades. Christy Gibson Marshall, the assistant principal, who did do one of the bravest things I've ever seen. She testified she saw the shooter's face and couldn't believe it was him. And the reason she couldn't believe it was him is because it was so unforeseeable. Mrs. Crumbley's hypervigilance also comes when you look at how she takes him for medical appointments.
Okay, we got about an hour of their time left, so
on his back, changed
about 45 minutes for us, I think.
I think of myself as a hypervigilant mother, and I've never noticed any moles on my kid's back, and I must need to go home and look. Because when I look at the actions of Mrs. Crumbley, she actually pays far more attention to that kind of thing and other things than I do. I could easily be sitting in her chair. When her son's experiencing headaches and medical issues, she's at the doctor or doing virtual visits. There's no reason to believe that's not true. With the headaches, they go through a whole process. She gets a whole x-ray done of his head. She takes him to the eye doctor to see if that's causing the issue. Ultimately, she pays and puts braces on his teeth. Then he's a bad brusher, so she's going to the extent of getting the braces off his teeth so he can get the cavities fixed, 13 cavities.
Oh my God.
I would go crazy on my kid. And she's just doing each thing she needs to do as a hypervigilant mother. And yes, a hypervigilant mother can have a drink once in a while. I'm a hypervigilant mother, and I not only have a drink once in a while, but sometimes I've been known to have two.
Don't know.
Or maybe a bottle.
Oh my God. Don't say that. There's nothing wrong with it, but don't say that.
Crumbley did her best as a mother. While going to the shooting range is not her thing, she's trying to find a way to bond with her son, who has just had his best friend move away.
You hate my client. You probably hate me. I'm a drunk that doesn't wash very often.
He has the cutest little kitten you've ever seen in these Facebook pictures. Board game nights with him, she's not neglecting him in any way. And if anything, she's going to the gun range for him, not because she enjoys it. You can tell how much she loves it when she gets up there, shoots a couple shots, and then just stands there letting him enjoy the activity he likes. And I do the same thing for my kid. He likes to go to skate parks. I would rather do anything but go to the skate park. But I sit there and watch and say, oh, that was amazing. And all I hear is, Mom, watch this, Mom, watch this, Mom, watch this. And I would rather do anything else. But
she sounds like a complete bitch. Stop talking about yourself. My children are psychos. They don't like spending time with me. I don't wash very often. I might drink a bottle of whiskey every now and then. I don't like anything my children do, but I tolerate it. So my client's innocent. This is bad. It's like 2 steps forward, 2 steps back. She's not making any headway here. She makes great arguments until she starts talking about herself.
Mrs. Crumbley on that day is trying her best to bond with her child and have a relationship. Showing the pictures of the messy house was just not necessary. And the prosecution explained to you they weren't trying to prove she had a messy house, but much of it was just so unnecessary that I would suggest they are trying to make her look bad. They do kind of make her look a little bit like a hoarder. But if you saw pictures,
God, I thought she said whore. I was
like,
God.
You'd be just as horrified. I've been so busy getting ready for this trial, ready for all the fun we've had in the court and through these last few weeks. I still have my Christmas trees up. I was complaining to my husband the other day, oh my God, we still have our Christmas trees up. This is embarrassing. And he said, hey, Shannon, we still have ceramic pumpkins up. And I realized, oh yeah, all of our fall decorations are out too. And right now I have piles of laundry all over. My kids over Christmas break put together stacks of stuff I need to take to the Salvation Army. I have donations of my own that need to go. My house right now, if they...
Okay, Megan Fox asks, why not talk about this? It's true. Everyone on the jury has probably had a bottle of wine too. The reason why is you are the professional representative of your client. You are there to act in a professional capacity. You want to be superhuman. You don't want to talk about your flaws. You want to talk about the flaws of the jury, their own flaws, the flaws of other people. You don't say, look, I know I'm representing this person. The defense's lawyer is a dirty, non-bathing, heavy drinking person whose kids don't like to be around them, and frankly, she doesn't like to be. I don't like to be around my kids either, and we don't do anything, and my children are psycho. It sounds really bad and unprofessional, and you don't want to go, oh my God, what kind of person is representing this poor defendant? You want to say, look, we've all been there. We all have a drink every now and then. We all sometimes we'll even have more than one drink. We've all got children that sometimes we don't. You want to make them feel it, not judge you. You want them to go, all right, I see this in myself. I see this flaw. I see this characteristic in myself, not judge her for doing these things. She's trying to do that. She's trying to say, look, I do this, so you do this too. But she's not saying the so you do this too part. And it just sounds like she's unhinged, deranged, and maybe a little bit unhygienic. It seems really unprofessional. And she just seems like a disorganized person. Go, oh my God, she doesn't have any of her shit together. So I guess we can assume her case isn't that great either. It's just something you don't want them thinking.
Did a search warrant today would look just as bad as Mrs. Crumbley's, and it says nothing about me parenting my child. If anything, when I come home from work, I make a deliberate decision. All right, listen, I can run around this house for 3 hours and try to get as much as I can done, or I can sit on my couch and watch old
And
episodes
MG
of
Law says
Jack
sometimes we
and
get paid by people on the
And I
internet
will
to
leave
have
my
lots
son
of
by
drinks.
Hanging out with her, watching trashy TV, then cleaning up my house because I get a chance to spend time with her. And Mrs. Crumbley was the same kind of mom. She was waiting until the holidays to have more time. She said she was going to clean her son's room. I would be screaming that I would make my son clean his room. But regardless, the project coming up was going to be to get those rooms in order. But at that point in the year when the holidays are coming up and you're getting ready for all of it and going through Thanksgiving, it does get to a point where you do have boxes piling up.
That's what she's trying to do. You're right.
To get to
But
Christmas break.
it's extra weird the way she's doing it.
There's reasonable doubt when you look at what Mrs. Crumbley thought after the meeting with Mr. Hopkins and Mr. Ejak. The state of mind she was in and her thoughts and what she was thinking come in through her statements. She thought everything was way less of a big deal when she left that meeting.
That's funny.
She thought leaving him in school with his friends was the better decision based on Hopkins saying peer support is a good thing. She thought making him an appointment was sufficient. An appointment within 48 hours was sufficient. That doesn't even mean the appointment was going to be within 48 hours. Reasonable doubt can be seen in the video when Mrs. Crumbley first sees her son at the substation. Her reaction to seeing him in this complete state of disbelief as to what's going on is to look at him and say, why? Why? She doesn't look at him and say, I knew you were going to do this. She doesn't look at him and say, see, I knew we shouldn't have bought that gun. She says, why? Why? And when he says, take care of Dexter, she cannot believe that's her son and goes back into the other room with her husband and says, what the fuck? He didn't even care. And while the prosecution asked questions about, well, she's not sobbing and we hear sobbing, and that's clearly James. James is sobbing. When you look at the video, if you decide you need to see it, Mrs. Crumbley is dabbing her eyes and wiping her eyes. And fine, she's not the crier some other people are.
Fair point.
Reasonable doubts can come from the statements in the heat of the moment at the substation when Jennifer Crumbley is in a state of shock trying to answer their questions. She says, he's never done anything bad. This is after she already has somebody saying, you really should have a lawyer there. She's still just talking about what the truth is. He's never done anything bad. One of the parents says he's a perfect kid. Jennifer Crumbley tells them the most of an issue he ever has is anxiety over tests. Jennifer Crumbley tells them everything was fine this morning. In the statements Jennifer Crumbley made when she was in the car and doesn't even know yet if there has been fatalities, she says he's never done anything. She acknowledges he ruined lives today. She says, it's the first time I've ever seen him do anything. She says, he's a good kid. He's never angry. He's mellow. He's not what he looks like. He's not a monster. And she's not a monster either. She explains to them in detail when they ask, he's never had mental issues. In those moments, she can't even think straight about life around her. She's worrying about a horse and her job and all kinds of random stuff. And ladies and gentlemen, when emergencies happen, life doesn't just stop. So the fact that she's able to function and think, I still need a job, I need some money, I need a phone that works, that doesn't mean she thought her son would terrorize and kill people and shoot people at a school. Her reaction when she finds out there are fatalities was genuine and honest, and she broke down crying, although she does continue to keep answering their questions. She explains why she feels like fatalities are different. She explained that on the stand. If he had shot people and injured them, it was something they could at least deal with. But a fatality is a fatality and can never be changed. The prosecution's attempt to misconstrue Jennifer's entire demeanor is a reasonable doubt in this case to show they don't have a strong case. They keep saying she's not sad. Jennifer explained she went into what can I do mode. She did show sadness if you read the text between her and Mr. Maloche. She showed sadness in the way that she shows sadness.
I don't think this is important, but
Stand up on the stand and say she didn't behave like the mother of a school shooter should behave is nonsense. None of them have ever dealt with the mother of a child, a teenager who has just killed people and shot many others. There isn't a right way in any handbook to say how you should or should not behave. Trying to make her look selfish and callous goes right with that same thing. How she reacts is how she reacts. You see it on the screen. It's really hard to pass judgment, although these police officers did, on how a person should react when for the first time in their lives, they walk out of their house and are surrounded with guns in their face, or how a person would react to be woken up in the middle of the night on a mattress with police around them and above them with guns in her face. So not only has anyone not been in the shoes of a school shooter and dealing with the kind of emotions that would come with that, they also don't know, and there isn't a standard reaction for how you behave when you're surrounded with guns in your face.
That's a good point.
It provides reasonable doubt that she didn't think he would hurt other people. She typed to him, Ethan, don't do it. She didn't say, don't shoot people. She didn't say, don't hurt anyone. She thought the only thing on her radar that could be possible at that point, knowing there's an open shooter and he has a weapon, was that he would kill himself. Reasonable doubt can be found in Jennifer's testimony. Jennifer's testimony is evidence. And at the end of the day, whether you believe, like, hate, however you feel about her testimony, the defense didn't have to prove anything. You still have to evaluate the prosecution's case for what it is.
Exactly.
However, Jennifer Crumbley did take the stand, and that was not easy for her to give you additional context about what was going on in the shreds of evidence the prosecution cherry-picked and put before you. The only person who's actually been consistent in this case, and you can find reasonable doubt from this, is Jennifer. She's consistent in what she says to police, what she says to her husband about things, and what she says to other witnesses who testified. You can find reasonable doubt.
I'll be back in a second.
Officers are very, very biased in this case. There is no doubt this is one of the most awful situations any one of them have ever been involved in. But it's also very clear they have a narrative that Jennifer Crumbley is responsible. And when they came in here and took that witness stand, they were going to mess with me on questions that were so stupid. Like this ATF agent telling me he doesn't know if teenagers could lie. Everyone in the room knows a teenager could lie. That was a low ball. Just answer the question. When you have an ATF agent that can't even get on the stand and answer a question that's common sense, that should speak volumes. That there's a narrative they've been directed to get out and they have an agenda. And that agenda, ladies and gentlemen, is not positive for Jennifer Crumbley. Making this big deal about money and cash that Mrs. Crumbley took out is a reasonable doubt in this case. Mrs. Crumbley explained her dad had accounts frozen. She didn't want her accounts to be frozen. Her dad put money in that day.
Speaking of frozen, I had to go get the frozen ice pack for my feet.
Her son's name on it wasn't done in any way to steal money from her son or show she doesn't care about him. She's the one that contributes every week from her paycheck into that account. And at the end of the day, she wants cash because everyone in the world absolutely hates her. She can't walk in places and hand them a credit card. Hey, Jennifer Crumbley's on that credit card. The only option she had was cash. She can't go in and start showing identification and things to get hotel rooms. And the more cash she can use, the better. The less she has to risk that people are going to figure out who she is. And remember, the world was essentially showing its colors against her as she was receiving threatening messages in the days that followed that shooting.
It's a reasonable point.
From other people, in her emails, in her Instagram, everywhere. They're so threatening, her employer is making her shut down accounts. Her friends, people that have been her people for years, don't want anything to do with her and don't want to be by her because she's that dangerous at that point in time. So for her to want to have cash makes absolute perfect sense. That's not a sign she's trying to flee. And also, if you're trying to flee, you don't go around local Oakland County and areas surrounding it and carry around a syringe of horse medicine. If you're going to flee, you abort mission on the horses. At that point, you're fleeing. It's very obvious Jennifer Crumbley, her intent was not to flee. Her intent is to stay safe. Her intent is to avoid threats. Her intent is to get this horse medicine to this horse, which obviously can't happen if she flees. It's clear when she's at the art studio that she's not hidden very well. She's outside smoking. Her husband's outside smoking. We saw the evidence of the cigarette butts in the snow. There's commercial buildings around and businesses within that studio. She's walking around taking a tour of the studio with her friend who owns it. And there's cameras all over the building. Obviously, she's not trying to hide if she's going into a building where you can see security cameras right on the outside that would document everything that's happening that we ultimately got to see in this trial.
Okay.
It's clear she's trying to stay the night in Detroit on November 3rd and didn't know where to go. It's clear from the video she's dead asleep at 1 o'clock in the morning when they're ultimately found and woken up to guns in their face. She testified she took 4 Xanax, and so did her husband. We also saw evidence there was a liquor bottle in the garbage, and presumably she had a drink. After 4 days of no sleep and not really eating, one can only imagine how hard 4 Xanax and a cocktail might hit you. So they make this big deal that there's text messages after 11 o'clock saying we might have been found. Well, earlier in those text messages that were admitted by the prosecution is Exhibit 430. The first text says, Marielle, this is Jennifer's phone. And Marielle was the other attorney at the time. Marielle, this is Jennifer's phone. James and Jennifer are using Jennifer's phone now. Next message. The other phone broke. And then there's a message to the Crumbleys, when you can be likely to call us. That's at 6:19. Then at 6:21, thank you, Shannon's calling you both shortly. Then at 7:02, I text, Marielle and I are going to come get you in the morning. We do not think it will help to make a statement that you're coming in or that we'll be in the morning.
It shows utter disregard for human life.
And as of tomorrow, you'll be back. My next message says, we can show them that everything we've said was going to happen did happen. Because the Crumbleys weren't running. They just wanted to turn themselves into a court. And law enforcement got on the stand and told you that's something people commonly do. It just didn't happen in this case. At 7:03, the Crumbleys write back, and we don't know if it's Jennifer or James because they're sharing his phone. Okay. Text to the lawyers that say Marielle, Shannon lawyers. Who knows why they sent that? I text, I am going to drive home from my office right now. I'll give you a call in about 45 minutes so I can get all of the bond factor information written down for you, for Marielle and me. I'm asking for bond information so we can go to the court in the morning.
I'm going to object. There's a prior ruling. She cannot be a witness. That was already dealt with.
Sorry, I thought I was arguing.
Wait, why is she violating attorney-client privilege here? That's what it sounded like to me. This is what me and my client were talking about privately. Don't do that. And I think that's why the judge cut her off. Yeah, don't do that. That's not something you want to be doing.
Go to the court in the
Your Honor,
morning.
I'm going to object. There's a prior ruling. She cannot be a witness. That was already dealt with.
Okay, she can't be a witness. All right. But yeah, don't do that.
Sorry, I
That's
thought it was
privileged
admitted.
information.
Well, you kind of off the evidence.
Okay. So they say at 7:37, okay, we'll be waiting. I'm going to call in 1 minute. Okay. Then at 11:14 on the phone that
Oh, wait.
both of them have been using.
So at some point, the attorney-client privilege was waived and all this came into evidence? Or did they say something stupid that opened the door to it? Oh, dear. They told her the privilege was waived, and that's how these texts came into be. Okay, so I guess somebody on the defense said something stupid that waived attorney-client privilege and allowed them to put this information in. I'm guessing that it was the defendant because she's pretty much the only one that could do it. Yeah, JC opened the door in her test. That's what I thought. All right. Never mind. I guess it's perfectly okay now.
A text is sent to the lawyers. Think we might have been found. Don't know. Just a heads up. Please check. It's not for a couple hours that they're actually found. But Mrs. Crumbley testified she didn't send a text and she was already asleep. Now, after those text messages, there's 2 more pages that are included in that exhibit. So if you do end up taking
Oh,
a
and she
closer look
testified
at
to that?
430, which is
Oh,
totally fine.
don't do
Just be
that.
aware that there's
Don't
another
waive your
exhibit that starts
attorney-client
this
privilege,
evening, and I don't know
please.
why that is. I just want to let you know that, and I'm not sure why that exhibit is like that. That was a new one we got obviously all today.
Oh my gosh! I just see that we somehow this slipped under the radar. It must have been when I went when I went to take a comfort break about 45 minutes ago. Amber Morris's legal question: the prosecution was able to get Ethan's journal in without him testifying. I would assume it's because at some point during his interrogation or part of his plea agreement or whatever, that he admitted it was his journal. So I can see that coming in without him testifying. I'm sure that it was stipulated to at some point. When Ethan pled guilty, he said it was not his parents' fault. Why couldn't that come in? Well, it would I guess you'd argue it would call for speculation to some certain extent. And fault, it not being his parents' fault, isn't exactly the legal standard. It's whether there was any negligence that caused or contributed to this effect, the ultimate result, which was the shooting. Does that make sense? I hope that makes sense.
In the days after Mrs. Crumbley and Mr. Crumbley are planning to turn themselves in, we know they're planning to turn themselves in because Exhibit A was admitted, which showed they were trying to find a hotel in Auburn Hills on Priceline for December 4th and 5th, in case they needed it for the event. There's no doubts, and I don't need to go on and on about this.
Okay, that's weird.
That was so clear at trial. They were afraid to go turn themselves into a police station where if they went, there would likely be other inmates or bad people there.
That's really weird. All right, I got no answer. I don't have an answer for you.
They were terrified.
I speculated and I was wrong again.
They wanted to go in through a lawyer.
This seems like it was a really weird trial.
They set an alarm clock, which was admitted by the prosecution, showing that on Saturday they were getting up at 6:30 or 6:45, completely consistent with their plan to go to
that's
the
lovely.
for an 8:30 hearing. This is also not James's trial. I am not standing here suggesting that James is guilty of involuntary manslaughter.
Yes, Duncan, Idaho, correct.
But it is important to point out that James was the parent responsible for all of the storage of the guns. Jennifer Crumbley barely knew a thing about them. She didn't object to them being in the house. She didn't object to buying the gun that James and Ethan were interested in. She didn't object to calling it Ethan's Christmas gift. She was not responsible at all for the storage of the weapon. It is misleading to suggest by the prosecution that 6-hour case was open on the bed and that it sat open like that all day with the ammunition box next to it. It's very clear that when James and Jennifer Crumbley were on the phone during that 7-minute phone call, Mr. Crumbley was looking for the gun, found the gun was missing, asked Jennifer Crumbley, where's the ammunition, pulled it out, and set it on the bed. It's not like that gun box, that case, was just sitting out there open at all times. When law enforcement did get there, find it on the bed, even they moved it around to the kitchen counter and other places. While this is not James's case, it is fair that Jennifer Crumbley would expect that he would have more flexibility in going to handle an issue at the school. That is not unreasonable and does not make her a bad mom. He's out in the Oxford, Lake Orion, Rochester area door dashing. She's the one with a professional career supporting the family and paying all their bills and trying to keep her job, which they may need to add the family on for insurance in this open enrollment period. She shouldn't be diminished as a mother because she was going to let father go to the school and handle whatever issue there was. Now, ultimately, they went together, but he's a DoorDash driver. She's trying to pay the bills. She's the breadwinner. At that time, he's in between jobs. She shouldn't be dinged for that. It's misleading for the prosecution to suggest there's been evidence in this case. She keeps guns in the car. She didn't say she keeps guns in the car. When she was interviewed, and if you really want to watch the interview, you can. Jennifer told law enforcement there was one time that gun was in the back of her car. That one time was when James put it in the back of the car, and she drove the car to the range. Her son and her had a experience at the range, and she drove the car back home, left the car locked with the gun in it, so that when her husband got home, he could put it away. It is not true that she was driving around keeping guns in the car. That is not what she said to police.
Got about 25 minutes left, I guess.
On the gun at all times. She called it a string lock. She testified that the key was kept in a separate place in one of the many beer steins they had. She testified that she did know where the ammunition was. She hid it in her drawer of jeans. And she testified that things were locked and hidden separately, and that Mr. Crumbley was responsible for hiding the weapon. If you are upset with how the weapon was hidden,
Mr. Crumbley,
that's not for you to decide. That's a
what have they done in your
James
name?
Crumbley. You're here to look at the case of Jennifer Crumbley and consider what she knew. She is not the person responsible for storing this weapon. I'm not trying to suggest she didn't know it was in the house, but she is not the person putting the cable lock on and off or doing anything with the gun. We saw her gun abilities when she went to the range and had to have her son show her everything about it. It's a gross overstatement to keep saying that the gun was his gift. It's very clear it was something bought for him to use at the shooting range, something that may one day ultimately be truly just his. But it's just like any of us giving our kids a laptop to use, a cell phone to use, a car to use, a jet ski. I have a friend that has kids, they have snowmobiles. Nothing different. It doesn't really mean the kids just have free access to all of that stuff. It comes with conditions, rules, and parameters. Unfortunately, this is a case where the prosecution made a charging decision way too fast. It was motivated by obvious reasons for political gain and media attention. And we know that because on 11/1, when the shooter was arraigned, the shooter was on Zoom, and so were the parents, and the media was aware. And when Mr. and Mrs. Crumbley were charged, and there was a swear to at the court, the media was all there, but guess who wasn't? Mr. or Mrs. Crumbley. Mrs. Crumbley testified she didn't even know there was going to be an arraignment, but the media knew. And then the prosecution came out with a big press conference, announcing it. I would submit that the plan was never to let the Crumbleys turn themselves in, but to turn them into a big charade of looking like they're trying to flee when they absolutely weren't.
Not unreasonable.
Prosecution and law enforcement have approached this case with tunnel vision from day one. Brian Maloche called it a witch hunt. I would submit to you it was. And once they charged these parents and the ATF, Sheriff's Department, Border Patrol, Secret Service, all U.S. Marshals, not Secret Service, when all these agencies have gathered around and hundreds of people are looking for the Crumbleys, it's really hard to say, we made a charging decision a little too fast. And in this case, you heard evidence that much of the evidence in the case didn't roll in until after the parents were charged, arrested, and in jail. To try to suggest having multiple phones as a sign of fleeing is just garbage. I think everyone here clearly understands why they bought burner phones and why they went and bought replacement phones with their phone numbers so they could use two-factor authentication to get into their accounts. Jennifer Crumbley is seen in the police interview at the substation handing her phone to law enforcement when they're asking questions. When the police tell her they want to take her phone for a search warrant, she doesn't want to hand it over right away, but it's not because she's trying to hide things. It's because it's her only line of communication. She doesn't really understand how a search warrant works until her husband explains it.
Okay.
She doesn't carry around a little diary of all the numbers, although police do let her get the numbers out. And it's the only way people can get a hold of her. And she's been in touch with them nonstop, as we can see when she's in the police vehicles. And again, although she's on her phone and there was a substantial amount of time where she's looking things up, communicating with people, trying to get things done, that doesn't mean she believed her son was a school shooter and had no emotions over what was happening. The prosecution has painted her out to be a person who lacks remorse. And I would submit to you that she would change everything if she could. And when she looks back and says there's not a thing that she feels she could have changed that would have changed something, you have to keep in mind that the suggestions by the prosecution are just ridiculous. Giving him a hug that day in the counseling office was going to stop a mass shooting. That's just ridiculous. There is nothing to prove that anything could have stopped a mass shooting when you're dealing with someone who is so manipulative and is a criminal and was a shooter in cold blood and pled guilty and took responsibility as an adult for his crimes. Finally, my last reasonable doubt card is blank because I've tried my hardest to come up with all the reasonable doubts the defense sees in this case. And like I said, each of you need only one to vote Mrs. Crumbley not guilty. But a lot of times jurors think of a reasonable doubt I miss because there's so much evidence. And we've already established, and I've admitted I'm not a perfect person and not a perfect lawyer. So I put a blank card before you so that if you have a doubt I've missed, you know you're not limited to what I've suggested or the defense has suggested. You're welcome to come up with your own doubts on your own.
That was weird.
And if you decide you want to dive in and read the truth between Mr. and Mrs. Crumbley and everything they talk about, you're totally more than welcome to. Those exhibits are all going back with you. And what I'll tell you is that you're going to find a lot of instances where Mrs. Crumbley is anxious, asking where her son is, where her husband is. You're going to see a lot of horse talk. You're going to see arguments between a married couple. When I read them, they read just like my husband and myself.
So you argue with your husband a lot too. Stop saying things about yourself. Stop it.
And then we just move on, and that's just how life is. You'll see messages in here that will certainly.
I know everybody does it, but don't tell them you do it.
Probably intend to do in bed that night. You will read a variety of messages that show real life between two married people that have a child. And it should make no difference that they may use their horse's name more often than their son's. And I'd also submit that every time you see them talk about when is he going to be home and what are we going to eat for dinner, even if they don't use the words spelled E-T-H-A-N, that's who they're talking about because there are only 3 of them in that house. At this point in the trial, I am asking that you find Jennifer Crumbley not guilty, not just for Jennifer Crumbley, but for every mother who's out there doing the best they can, who could easily be in her shoes, for every parent doing the best they can, who could easily be in their shoes, for every parent that has snippets of text messages that could be read and make them look like horrible monsters, for every parent that has fights with their kid on text message that also would make them look like terrible parents, for every parent that's ever had a hobby and has not spent 24/7 with their child. That should not be held against parents. For any parent that's ever had an affair or spent time communicating on an affair, that says nothing about how much you care about your child or your expectation of whether or not they would commit a school shooting. Most people who have affairs would still not expect their child would do this.
What? Okay.
I do wish more than anything, this case could bring justice to the victims of the shooting, the victims of the terrorism that took place that day, and the victims of their families. I wish more than anything, it really could be a result that would be a Band-Aid to make everyone feel better, but it can't be. First of all, it brings back nothing for the people who have lost. It certainly doesn't bring back any lives. And if anything, this is not justice. This is not how justice works. This case does nothing for the people who have already lost everything. Many of the people sitting in this courtroom. And it does nothing to bring back the tragedy that unfolded.
This kind of sounds weirdly a little bit like jury nullification. You know, regardless of whether there's a case here, it doesn't really matter. This doesn't bring back the kid. This doesn't solve anything. This sounds weirdly like a jury nullification argument without arguing jury nullification. I don't like this part very much. Like, yeah, no, we're not going to bring back any of the bodies. Yeah, this isn't going to solve anything. We're not getting it. The society doesn't get anything out of this. So find my client not guilty.
On November 30th. At this point in time, the prosecution cannot prove.
Well, sounds like I'm in good company. Kurt and Megan noted it. Peter and Tragos said the same thing. Oh, okay.
There was a danger that existed by her son.
I guess I'm in good
That
company.
required her to exercise reasonable care. They cannot prove that she was grossly negligent and that there was any way she could foresee that this would happen, as awful as it is, and we all stipulate it is. At this point in trial, I always have to sit down. This is how the court rules work. Prosecution gives a closing, I give a closing, they have an opportunity for rebuttal, and then I don't get to say anything else. And I'm sure you can see from my demeanor in trial, when the prosecution says something that I know I have an argument against, I get anxious, you can see a reaction, and I'm not going to do that. But I am going to tell you that as they argue, I will have many things that I wish I could get up and say, that's not true, and argue against. So what I would ask is that when you go back in the jury room and begin to deliberate, you think about and ask yourselves, what would Shannon Smith have said in response to the rebuttal?
Kind of like that. I like that a little bit.
You consider that in your deliberations, because I guarantee you I'll have a very hard time sitting here knowing that the prosecution gets the last word when I know the defense would disagree with it. And I am asking each of you to vote that Mrs. Crumbley is not guilty because she is not guilty, and because a not guilty verdict is the only fair and just result in this case. Thank you. Yes.
We did get the last word. I get the last word. The people do.
All right, we do have to slow her down because she does talk a little bit faster. So let me slow her down to 1.25 speed. And we don't have much time left here. Let's kind of get an estimate for how long we have here, shall we? Go away. No, there we go. We're currently at 7:50, and she goes to. Damn it! Good thing I checked the time. Oh, so she goes about 15 minutes. So we've got about 10 minutes more. Let's go back to the 7:50 mark. Good thing I noticed that, huh? Got the dog sleeping there. Fast forward. All right. She does get the last word. Now, my assessment of that was I would give just based on the closing arguments. As you know, I've seen very little of the actual trial, and I'm just reacting because a lot of you asked me to do it. I would give the defense lawyers' closing argument probably a C to C minus, somewhere right on the border of a C to C minus. Why? Because I thought all of this weird me stuff. Look what a horrible, weird, unkempt, unprepared mess of just of a human being I am part was a straight up F. I hated it. I personally didn't like anything about it. It was a huge turnoff, and I thought it sent a completely inappropriate and incorrect view to the jury. But when she was just talking about the case, when she was talking about the grounds for reasonable doubt, I think she was a solid A minus B plus. So she was great when she was talking about the actual case and the reasonable doubt that exists. Great job. When she was doing that whole me, look at me stuff, yeah, I didn't like it at all. So C minus. Crystal Pontek says you're generous. Okay. No, I think if she just would have stuck to the reasonable doubt issues and not spent a good 25, 30% of her time trying to say, look at how weird I am and how weird my family is, I think it would have been a little bit better. But that having been said, at this point, I'm still very much in the just based on what has been said during the closing argument, in the camp of the defense. I don't think the prosecution proved the elements of they didn't explain how they proved the elements of the crime sufficiently enough, and the prosecution didn't do that, and the defense didn't have any fatal flaws in her closing argument. Again, that's just totally based on this. So I would still say just based on the closing arguments, there we go. But let's see what happens here on the rebuttal.
Manslaughter. It's not a burden that I have to prove every single fact about the case.
Oh, you have to prove every single element.
That's not the law. That's what she told you the law was. It's not the law. The law is I have to prove every element beyond a reasonable doubt.
Sure.
Beyond a reasonable doubt. Not any doubt. Beyond a reasonable doubt. The defense gets to decide how they present their case. They get to decide that. She gets to stand up and say what she said. But your job is to listen to the facts of the case. Your job is to listen to what the judge tells you the law is. Your job is to tell you to let's look at the evidence, the people sitting here, not what somebody else wants to have said that they said, but what they actually said. Your job is to consider not what lawyers say about their own life and their own circumstances and their opinion.
That's why you don't want to do it.
Consider the facts and the evidence.
That's why you don't want to do what she did, because now you can just
address a couple things.
discount everything.
There was absolutely no evidence at all presented to you that anybody at that meeting told Jennifer Crumbley it was no big deal. There was no evidence of that. There was no evidence at all that Jennifer Crumbley was very surprised by how long the meeting lasted. Jennifer Crumbley didn't say that. That's not in the evidence. I don't have to prove, the people do not have to prove that Jennifer Crumbley knew that there was going to be a homicide or a school shooting. As Lieutenant Willis pointed out correctly, if she knew exactly what was going to happen, she'd be charged with murder, ladies and gentlemen. She is not. She is charged with involuntary manslaughter. And the elements, you'll get them. I read them to you. The standard and what I have to prove is not that she knew that her son would go shoot up the school and kill 4 kids. I have to prove that she had a legal duty.
Not that she executed it in the wrong way, just not in the most effective way.
Did not take steps to take care and protect the other children in that school when there was a reasonable foreseeability that ordinary care was required. The smallest of things. The smallest of things. I apologize to the law enforcement in this room and any listening that I have to stand here and to defend their integrity, but I do.
Why would you apologize for that?
That Special Agent Brandon and Lieutenant Willis and the other law enforcement that took the stand here, including.
I'm objecting because I'm allowed to argue based on what's in evidence, and Ms. McDonald is trying to make me sound like I've done something wrong, and I didn't. My argument was proper.
She's arguing. It's my rebuttal.
Yeah, and overall, you commented on the statements of police officers. You argued about the statements of police officers. She gets to argue about the statements.
The exact quote was, they probably did that to all the witnesses in the case. If you believe that, then you believe that the sheriff's office, Lieutenant Willis, Special Agent Brandon, the ATF, the federal marshals, the Detroit Police Department, anyone who the evidence tech, they were all in some sort of conspiracy. That's what you have to believe, and I know that that's not what you're going to find. Look at the evidence, apply the law, and decide what the truth is. That's all I've ever asked you to do. That's all the judge is going to ask you to do. Nothing here was designed. Nothing here was made up. And I don't have to convince you of that, because I know that you're going to use your heart and your mind and your sense of reason.
Don't use your heart. No.
first statement Jennifer Crumbley makes about this gun, her son's gun, was at the substation after the shooting, and this is what she said. It was hidden. It was hidden. That's what she said. It was hidden, ammunition separately. It was hidden in a dresser. It was hidden. That's all she said about it.
Yeah, so
The school's actions or inactions do not excuse the culpable behavior by defendant. Ladies and gentlemen, he literally drew a picture of what he was going to do. He drew a picture. It says, help me. It has the drawing of the gun that she bought him, posted, and bragged about. Blood everywhere. The thoughts won't stop. The world is dead. He drew her a picture. Pretty egregious and unique circumstances. And in fact, it is absolutely not true that we have to worry that we'll all be sitting here. We agree on one thing.
we do now
Her testimony
because of
is
your
evidence.
your
Jennifer Crumbley's
case.
testimony is evidence, and you should consider it. And when you consider it, I'm confident that you will agree it is not consistent at all. It wasn't even consistent from her direct examination to her cross-examination. She acknowledged sitting here when Mr. Keys asked her about, where's his phone? You said you took the phone. You heard what she said. We took his gun away. We took his gun away. I don't know.
Well, Ona Wall says it was hidden does not mean secured, obviously. Well, exactly, but it also doesn't mean not secured. They asked, where was it? She said, it was hidden. Not, was it secured? Just where was it? And it was hidden is an answer to that question.
Proof light beyond a reasonable doubt. I already told you that. You can infer consciousness of mind. And what does that mean?
Consciousness of mind?
You delete text messages and you lie because you know she knew she did something wrong. The question about why Jennifer Crumbley didn't take one of these small actions.
I don't like these small
Find out where
action
the gun
things.
is.
I don't like this statement. It's
It
just
looms
weird.
large in this courtroom. There is no one it looms larger for than the victims and the family members of those kids who were killed on that day. We don't have to prove why. But remember what she said. I wouldn't change a thing. Just hours ago.
And again, I wouldn't change a thing. I don't know what the context of the question was. I'm just saying if she was asked, if you could go back and do it again, what would you have done differently, or would you have done anything differently? I mean, the answer to that almost has to be no, because she made the decision based on the information available to her at that time. But if you say, knowing what you know now, would you have done anything differently? Then perhaps that answer would ultimately be, almost necessarily be yes. So it depends on how the question was phrased. And I don't know how the question was phrased.
She said, I wouldn't change a thing. This prosecution is about nothing else except the facts of this case and what Jennifer Crumbley did and what she didn't do. If only I could look at the faces of these parents who are dealing with
Exactly,
unspeakable
Megan.
darkness and grief. If only I could make that better. I could appease them, as defense counsel suggests, by charging Jennifer Crumbley. These
So
are
that's
the
what she
parents
did.
Of Hannah St. Juliana. These are the parents of Madison Baldwin. These are the parents of Tate Meir. These are the parents of Justin Schilling. And not just their parents, they are mothers and they are fathers and they are sisters and their brothers. And do not think for 1 second that this prosecution takes any of that pain away, because it doesn't. This isn't an effort to appease anybody. Your verdict means one thing. It means Jennifer Crumbley is guilty. 4 counts of involuntary manslaughter beyond a reasonable doubt. And I am not going to stand here and tell you that that's going to take away this pain that these families feel, because it will not. I won't stand here and say that the pain will be gone from Molly Darnell or Chrissy Gibson Marshall or Special Agent Brandon, who ran out of that office so quickly that his chair was spinning. Or Ed Rogrowski, who viewed the surveillance video to identify the path of the shooter, and it was burned in his brain forever. Or for Lieutenant Tim Willis, who answered the call to lead, and maybe the biggest
Okay, this is a little bit overwrought
but
here.
he did not back away from. Don't render this verdict for the hundreds of kids in that school. It will not appease them. Nothing will. But you are now called upon. You are called upon. You are called upon to do your part as jurors, to keep the oath that you took, to be fair, to be honest, to be impartial. You are the ultimate fact finder. But what happened that day? You are the ultimate fact finder of the truth. We have met our burden. We have proven beyond a reasonable doubt that Jennifer Crumbley is guilty of 4 counts of involuntary manslaughter for failing to exercise ordinary care when the smallest, tragically simple thing could have prevented it. It could have saved Hannah. It could have saved Madison. It could have saved Tate.
No, if she don't do this choking up thing.
It could have saved Justin. And she sat here and she said she wouldn't do one thing different. And lastly, I'm gonna address the question I know that on minds of a lot of people in this courtroom and a lot of people listening. I'm gonna say what I know they're all asking and they want to say. When she took the stand and she testified about her own loss, and she was asked the question, "You lost everything." She said yes. She hasn't lost everything, ladies and gentlemen. Her son is still alive. Find her guilty of 4 counts of involuntary manslaughter. Thank you.
Well, there we have it. I like the stacking cam here. There we go. There we have it. That's the closing arguments made by both sides. I thought the prosecutor's rebuttal was stronger than her closing arguments, the initial closing arguments. I thought her performance, I thought, was a little cringe, a little overwrought, a little theatrical. But I thought the points she made were a little better than the first time around. I still don't, again, based on what I've seen, based on what they've said that they proved here during the closing arguments, I don't really understand how they proved the elements of the crime. It does seem like there's hurt and angry parents. Obviously, there's frustrated people in town who are angry about what happened, and they want they want everybody to pay. They want their pound of flesh, and the jury gave it to them. I think in a very, very dangerous judgment. I think this judgment is dangerous. It sets a horrific precedent, and other states are going to pile on. Other courts in this state are going to pile on. It's going to go to different things. It's going to go to vehicles. It's going to go to knives. It's going to go to I don't like the slippery slope argument because I think it takes things to like absurd levels. But this is a legitimate case where it can start down a very slippery slope to where parents are supposed to know absolutely everything, and they can go to jail if their children do something that harms a third person. That's my feelings, my uneducated about this case. And you guys wanted, well, not everybody, some of you wanted me to react to this. I did. That's my reaction to these things. I wasn't happy with the prosecution of the case to begin with, for exactly the reasons that I just said. It's bad news. Well, I believe that's it. That's what I was trying to articulate. That they need their pound of flesh because they didn't get it through a trial of the actual shooter. He pleads out. He doesn't have to go. He doesn't have to take public accountability for his actions. They don't get the satisfaction of going through the trial. So they need to see someone. They need to dig their pound of flesh out of someone. And I think that's what they're doing. Now, at this point, if I'm her husband, I'm just like, all right, plead the fifth on everything, which I don't really understand why she didn't. But yeah, plead the fifth on everything and just get ready to take up residence in the Gray Bar Hotel, because it's clear that it's clear what the people in that area think. All righty, well, there we go. I don't know how satisfied you are with that review, but I thought it was very interesting. And I thanks for bringing it to my attention. Like I said, I was doing other things and didn't have the opportunity to pay close attention to what was going on. But yeah, I think husband's cooked. It sucks to be him right now. Sucks to be her right now. We'll see how it goes. All right, peeps. Thank you for joining me here for my little show that we did. We went almost 4 hours of my 2-hour show. It's currently 3 a.m. here. I've got to be awake in 4 hours. But tomorrow is my Friday, because actual Friday, tomorrow's, well, actually it's today now officially. It's Thursday. Friday, Saturday, Sunday, Monday are a holiday here, so kind of free. it's a pseudo Friday. And so what's going to happen here, and we're going to send you over to Megan Fox. She's talking about the juror interview here. She's got a great thumbnail. The thumbnail is hilarious. We're going to send you over to Megan Fox here in just a quick second. I just want to let you know that tomorrow, Thursday, Chandler Remington and I will be doing our weekly O.J. Simpson trial. We're looking at the closing arguments. Barry Scheck is in the middle of doing his. We got about 3 more weeks to go, and then we'll start a brand new trial on Thursday. Friday is going to be kind of a chill stream at this point. We've got a few cases to update you on. The Aguilar Mendez case, the 18-year-old Guatemalan that was tased by the cops and charged with murder because a cop, ultimately aggravated manslaughter because a cop dropped dead a few minutes after he was put in the back of the car of all sorts of heart problems. We talked about the motion to dismiss. The state has submitted their response to the motion to dismiss, and it's very, very unsatisfying. We'll talk about that. Do a little bit of update on Sarah Boone's case. Where's Courtney Clenny sitting? What's up with the YNW Melly trial? And there's other cases we've got to talk about. So it'll be a chill stream, kind of a catch-up stream, and we'll do that on Friday evening, as always. Now, we don't do the Friday mornings; we do Friday evenings, and then we'll see what happens over the weekend, because I got a lot of time to kill. It's a holiday. All right, everybody, thank you so much for being here. Is it hot there, Jeff? No, it is freaking cold here right now. Magnolia Gypsy, what are we looking at for temperature right now? It is 1 degree Celsius, which is like 33 degrees Fahrenheit. So yeah, it's cold. Anyway, thank you so much for being here. Maud, bless you. I know some of you have been here from the very, very beginning. Thank you so much for taking time out of your schedule to be here and to do your Maudie goodness. Chat. You are the greatest chat on the internet. I deeply appreciate every single one of you to be here, part of the community, all the likes that you've given me, the support, the monthly memberships, the super chats, everything. Oh, and I did have to mention that we had a super thanks to yesterday's video from Earl Anderson. Gave a $10 super thanks for yesterday's show. Earl Anderson, if you're watching this, if you ever see this, thank you so much for that. Deeply appreciated. So there we go. You are the greatest. Absolutely, Ronan. You are one of the greatest. I said so. Dang it. The Vice Squad rules. We'll see y'all tomorrow. Everybody take care. Go say hi to Megan. We'll see you later. Larax saying out as soon as I find the outro music. Then we'll say out. Give me a second. Larax saying out. Peace.